matters. One anticipatory bail, 1 month before I made a mention of actually,
You come
and a regular bail.
Mr. Sharma, will come after vacation.
Millards, anticipatory bail matters.
Bail, no, if it can be adjusted, I'll see.
Millards, anticipatory bail, they are moving after. Who accused your lordship already allowed.
Let me see.
I am filing the
Anticipatory will tied up matter, my lord. So I pray for kindly to take it.
My lord, fresh transport petition matter has been posted to 13 my lord.
Yeah.
Not a second appeal matter. Trace admission and the instruction is required, man. You have taken over Monday or day.
So 9 matters the distance, the reserve clearly list. Item number 64. That is non-selection, cash cycle. Monday.
Not possible.
In between, 4 to 5 years already passed.
So, 1 more month will pass. What is the difficulty? It will be taken up comfortably after vacation.
It is such a qualification.
No, in the rush during vacation, it is very difficult to take. Anyway.
Monday.
Yes.
Note of submission,
Yes.
Lordship. I brought the judgment of the Lordship in Sarojin Sahu's case. Hypertechnicality should not be.
Yes.
Supplementary list item number 1 for judgment.
Okay. Declaration of the case. Thus, from a conspectus of the analysis of the facts and law involved, this court is of the view that the services of the petitioner for the period from 23/9/1995 to 9/1/2006 need to be regularized, and all consequential service and financial benefits, as admissible in law, be disbursed in her favor. It shall be the primary responsibility of the state authorities, opposite party numbers 1 and 2, to ensure that this order is complied with by the governing body of the college without any further delay. The salary as admissible from 10/1/2006, consequent upon regularization of a service, shall also be released after adjusting the amount already paid to her, along with fixation and disbursement of her full pension. In the result, the writ application is allowed. The opposite parties are directed to pass necessary orders in terms of paragraph 14 of this judgment within 2 months from the date of receipt of copy of this order, or on production of certified copy thereof by the petitioner.
Grateful.
Item number 2 for judgment.
For the foregoing reasons, therefore, this court finds that the claim of the petitioner for regularization of his services from the date of his initial appointment is without any basis. Resultantly, the writ petition being devoid of merit is therefore dismissed.
Item number 3 for judgment.
In the result, the writ application is allowed in part with the direction to opposite parties to consider the case of the petitioner for appointment against the post of assistant Hindi advertised on 31/3/2012, by granting him age relaxation and in accordance with law. This exercise should be completed within a period of 2 months from the date of production of certified copy of the order by the petitioner.
Item number 4 for judgment.
For the foregoing reasons, therefore, the writ petition is allowed in part. The opposite party numbers 1 and 2 are directed to pay interest at the rate of 7% calculated from 31/7/2008 till the date on which the basic gratuity of rupees 2.50 lakhs was paid, and further 7% on rupees 5 lakhs from the said date till the date on which the balance amount of rupees 5 lakhs was actually paid to the petitioner. This order shall be carried out without any further delay, and in any case not later than 2 months from the date of production of certified copy of this order.
Item number 5, trace submission.
Pass over.
Item number 6.
May it please your lordship.
Yes.
My lords, the petitioner is the informant in the criminal case. She has approached this honorable court for transfer of the GR case number 135 of 2024, arising out of Dhusari PCPS case number 55 of 2024. That is in Annexure 1, my lords, page 12.
Yes.
From the court of learned JMC Dhamnagar to the court of learned SDJM Bhubaneswar.
Why?
My lord, because the informant in this GR case, she has lost this affair against her in-laws. It is a love marriage. She got married to the opposite party number 3's son, her elder son, in 2017. She was subjected to constant torture, and because of that, she lodged complaint twice earlier, which is in Annexure 2, my lords. May kindly see.
So why do you want transfer?
My lord, because there is an apprehension of her life. Her life is at risk, and my lord, in the meantime, the charge sheet has also been filed.
So what are you going to do about it? It is the state's case.
Yes,
State will prosecute the case. You are only to
attend the court proceeding, my lord, it is necessary for me to attend the court proceeding.
No. Come out with a yes. Tell me that there must be a compelling necessity for transferring the criminal case, and that too at the instance of the informant. You are the informant. You have got nothing, no role, very limited role. You will have to depose as a witness. That's all. And you may, in terms of section 302, you may submit your written note of submissions after the prosecution has completed its
My
case.
lord,
That's
I may be permitted to submit the charge sheet. In the meantime,
No,
they are
but-
very influential people and the main sections, that is 379 and 354.
have faith in
Both have
have
been
faith in,
deleted.
have faith in Indian judiciary.
I do have, but
Judiciary is-
they have already got deleted by the police. I have not, no
You
faith.
challenge it. You challenge it. If they are deleted, you file a protest petition.
Yes, because of that, I have to approach the lower court now.
No, the court will take care.
But she is,
If you are apprehending danger to your life, that also you can bring it to the notice of the court. The court can also take care of that. Can pass necessary orders for your protection. But for that reason, transfer. No.
I will convince your lordship, may kindly wait.
No, if you can
Adjourn.
convince me today, you can never convince me.
But there is
Miss
real apprehension. My lord, may
Mrs.
kindly
Rajgaria,
action to.
Mrs. Rajgaria,
Yes,
please
Your
listen. If you are unable to convince me in 5 minutes, even if you take 5 days, I will not be convinced.
My lord,
I've got the seed of it. It will not be transferred.
as Annexure 3 may kindly be seen.
Yes,
Annexure 3, there are 2 complaints earlier on 4/3/2020.
I will give you.
7/2020.
I will grant you liberty to raise this part before the court below about the danger to your life. If you have any apprehension of danger to your life, you can always
She
raise
is a
it.
permanent resident of Bhubaneswar only. She is a mother of a young child.
No. This is not a matrimonial case that will be transferred.
Yes, definitely. But for the convenience of
No.
the parties, it is.
No, the witness are from Bhadrak. They're Bhadrak.
No, her husband is
Where?
residing in Bhubaneswar.
From Dhusuri.
Dusuri.
Dusuri.
Dusuri
But-
in Koti.
In the district of.
Dhamnagar.
In the district of Bhadrak. So,
Bhadrak. Maharaj, the main witness, who is her husband, who is residing with her at Bhubaneswar only.
that is not,
He is-
he has not come for transfer. If he is inconvenienced, he should have come for transfer. नहीं होगा.
होगा.
No.
इसमें है बहुत कुछ.
No.
Real apprehension
No,
ये तो
no.
मैं कभी नहीं आती.
No. You may, if you, I am giving you an opportunity, you may seek withdrawal with liberty to renew your prayer regarding a protection for, in view of the apprehension that you have, whether rightly or wrongly, whatever. If you have any apprehension of danger to your life. you
There
can
is
move the
real
court.
apprehension,
So
Maharaj.
you move the court below. The court is competent enough to grant you
For
protection.
that, I have to visit Dhamnagar. And
No.
once I visit Dhamnagar,
You
then
can't say that you will never visit Dhamnagar. Why? Only
who
because.
will,
No. You can lodge an FIR online also. You can submit an application through the PP also before the court. No. Either you withdraw or I will pass an order.
no,
All right. You will withdraw. Permitted to withdraw with liberty to. Learned counsel for the petitioner seeks permission to withdraw the transfer application with liberty to move the trial court for her protection as she apprehends danger to her life. Considering the submissions, permission is granted with liberty as aforesaid. Yes,
highly obliged.
you got a very good order.
Item number 7.
My lord, I am in GC, my lord.
Yes.
My lord, I have it's a matrimonial transfer of CRP number 70 of 24 from Bhadrak to Baleshwar. Why I am seeking transfer, my lord? Your lordship may kindly turn to page 8. Both are doctors, both are posted in Baleshwar. And your lordship will see page 8. The wife files it.
Was this case earlier before me?
No, my lord.
Similar case, I think.
No, my
I
lord.
see.
It is filed in 24 only.
All right. So both are posted at Baleshwar.
Both are posted at Baleshwar, but she gives her address in Baleshwar, but at present in Bhadrak and files the case in Bhadrak. My lord, they cannot live together. If a notice is issued and it's referred to mediation, I think it can be solved. My lord, both can.
No. Why unnecessary notice will be issued, Mr. Bose?
My lord, may kindly see page 8. Kindly see page 8.
No, what is the ground? No, let us see the ground. Let us
Both
see
are
the
Baleshwar.
ground. Where have you mentioned it?
My lord, we
Right.
see page 8. Dr. Sonia
No.
Behra.
Sir, just a moment. Where have you said in your transfer application regarding the, where have you stated the grounds for transfer?
My lord, yes, I have stated that deliberate paragraph 5. The petitioner humbly submits that opposite party to harass the present petitioner deliberately filed the case at Bhadrak, but she is working at Balesur.
That is too far-fetched. This does not give out a ground. Only to harass you, she has filed a case. By
Yes,
saying so, it cannot be transferred.
and her own pleading, your lordship will see at page 8, her own statement. This is her case filed in Bhadrak. She writes that she is in her permanent address at Balesur.
So, she doesn't seek transfer. You are seeking transfer.
I am seeking transfer because
Naturally.
she has deliberately filed in Bhadrak just to harass me.
No. The court cannot simply give a finding that it is only to harass you that she has filed the case before Bhadrak.
My lord, my entire endeavor is that parties cannot now live together because they are separated since last 2
So
years.
you move for mediation in the court below.
My lord,
wherever it
I am
is pending.
seeking, if he comes here, mediation can be
No,
done in
No, I'm not convinced. I'm not convinced, Mr. Bose. I'll not interfere at all.
your lordship may only issue notice. I am not
No,
seeking imprimatur.
No notice. No notice.
My
No,
lord,
no.
I think it can be solved.
No, you can. If you are, you see, in the family court itself, we have counselors. Principal counselor, then counselors, then there's a mediation center. If you want,
My lord,
really want
my
the matter
lord,
to be disposed of
My lord,
through mediation.
my entire endeavor is, if it is done in outside place, then it can be solved.
No.
This
no.
is my instruction from my client.
No. He's a doctor. He can travel for 70 kilometers from Balesur to Bhadrak. It is nothing. Why should the case be transferred?
No, my lord, I am not on that. My entire endeavor is a mediation.
So
And
you
mediation
file an
in the
application
third
in the
place.
court below. You
No,
file an
third
application
place.
in the court below. It will be referred to
My lord,
mediation.
in a third place, because there the
No,
situation is not such.
No. Then you file a writ application. Invoking the
Well,
provisions of the Legal Services Authorities Act to have the mediation at some other place.
My
Can
lord,
be
your
done.
lordship can also exercise power. I don't say
No,
that
no,
your
no.
lordship cannot.
I will not. I can, but I will not.
My lord, if your lordship says I will not, then I have nothing to say.
No,
I have
yes.
nothing to say.
Yeah, actually, practically, you have nothing more to say.
My lord, our entire endeavor is that it can be solved.
So, better beat a retreat, or I will pass the order.
My lord, I cannot, because your lordship knows
All right,
nowadays what is the problem.
The petitioner. All right. I understand. And sometimes these clients can also misunderstand you.
Yes,
The
yes.
petitioner is the husband of opposite party and seeks transfer of CRP number 70 of 2024 filed by he was disengaged. That is from 18/5/2018 till he was reinstated. It is submitted, the representation as above has not been disposed of as yet. Such being the facts, the writ application is disposed of, directing Collector Koraput to consider the representation dated 6/4/2024 submitted by the petitioner, if not already disposed of,
Yes.
in accordance with by passing a lawful order within 2 months under intimation to the petitioner. Yes.
Item number 11.
Item number 11, may I plead your lordship? Lordship, I am for the opposite part number 2. On the earlier occasion, your lordship had put
Opposite party number 2 is?
Indira Gandhi Institute of Technology.
Yes.
On the earlier occasion, your lordship had put a query on me that after making a favorable recommendation to the government, whether the institute can take a different stand before this honorable court. Your lordship, I would not like to add anything and not deny the fact that there was a recommendation made by the institute. But my humble submission, subject to your lordship's acceptance, would be that if a proposal or a recommendation which has been made by a certain institute or a body if it is subject to the approval of the government, then and it does not alter or create a legal relationship, then that recommendation in this case, what was the dispute was that the board of New Okla Industrial Development Authority had made a recommendation to the government that the age of superannuation of the staff of the authority should be increased from 58 to 60 years with immediate effect. The government, what they did, that they took a decision to increase the age retrospectively. And this matter was before the Honorable High Court, and the High Court decided that the age should be increased retrospectively. The government decided that the age should be increased prospectively, but the High Court held that the age of the staff should be increased with a retrospective effect. Now, Lordship, against that decision, the board of the Noida Authority preferred an appeal before the Honorable Supreme Court. Before Honorable Supreme Court, there was a argument on the part of the respondents that since the board had itself made a recommendation that the age of superannuation should be increased with immediate effect, then how can they now come before the Honorable Supreme Court and take a conflicting stand? In that regard, I would like to place para 27 of that judgment, Your Lordship, at page 448.
Yes.
May I be allowed to?
Yes.
The argument of the respondents that the appellant authority is stopped from claiming that the government order issued on 39/2012 cannot be given retrospective effect from 9/7/2012, since the board resolution proposed an increase in the retirement age of its employees with immediate effect is unsustainable. For the principle of promissory estoppel to apply, one party must have an unequivocal promise intending to create or affect a legal relationship between the parties. The recommendation of Noida Authority cannot create Lordship, the institute cannot be stopped from saying that even if the proposal was made and if it was contrary to any law or provisions of law, then that proposal will not have a binding effect on the institute, Your Lordship. Now, Lordship may be allowed to go into the merits of the case.
Merits, I think what merit?
Lordship, I want to place some.
On last date, my friend submitted everything.
What merit you want to submit?
Lordship, I would like to cite a decision of the Honorable Supreme Court on whether what are the legal effect when a junior post is given a pay scale of a senior post, Your Lordship. That is 2008 SCC 580, Your Lordship. Here, in this case, Your Lordship, what was the dispute was an employee of CRPF. He was working as a radio operator, and he, on the recommendation made by the director of CRPF, he was claiming a pay scale of a promotional post of a assistant sub inspector. So he filed a writ petition before the Honorable High Court, and he said that there was a recommendation from the director, so I should be given the pay scale of the ASI, so the promotional post. The learned single judge dismissed the writ petition. Then he preferred an appeal before the division bench. The division bench, what they said, that since there was a recommendation of the director of the CRPF, who is the principal employer, now the CRPF cannot take a conflicting stand before this honorable court and say that we will not give him promotional post. So the division bench set aside the judgment of the learned single judge. Now, in that, against the decision of the division bench, there is an appeal preferred before the Honorable Supreme Court. Your Lordship, may I be allowed to place para 8 of that judgment at page 584?
Yes.
In our considered view, the division bench of the High Court was not right and justified in straight away giving direction to grant pay scale to the respondent when there is no material placed before the court for comparison in order to apply the principle of equal pay for equal work between radio operators of CRPF and the radio operators working in civil side in the Central Water Commission and Directorate of Police Wireless. In the absence of material relating to other comparable employees as to qualifications, method of recruitment, degree of skill, experience involved in performance of job, training required, responsibilities undertaken, and other facilities in addition to pay scales, the learned single judge was right when he stated in the order that in the absence of such material, it was not possible to grant relief to the respondent. No doubt the director of
But here there is a finding. Here there is a specific. I remember having seen where it is said that the nature of work between both employees are
Yes,
same.
Your Lordship. That part is also dealt in this judgment, Your Lordship. I'll place those paragraphs before you. CRPF made recommendation. No doubt, the Directorate of CRPF made recommendations to the pay commissions for giving higher pay scales on the basis of which claim is made by the respondent for grant of pay scale. The factual statements contained in the recommendation of a particular department alone cannot be considered per se proof of such things, or they cannot by themselves vouch for correctness of the same. The said recommendation could not be taken as a recommendation made by the government. Even otherwise, a mere recommendation did not confer any right on the respondent to make such a claim for writ of mandamus. So then, Your Lordship, maybe I may be allowed to place para 11, where the Honorable Supreme Court has said that the government only can decide whether the pay scale should be merged or not. Para 11, it reads as para 18 of the judgment of this court in state of UP versus JP Chaurasia. The first question regarding entitlement to the pay scale admissible to section officers should not detain us longer. The answer to the questions depends on several factors. It does not just depend upon either the nature of work or volume of work done by bench secretaries. Primarily, it requires, amongst others, evaluation of duties and responsibilities of the respective posts. More often, functions of two posts may appear to be the same or similar, but there may be difference in degrees in the performance. The quantity of work may be the same, but quality may be different.
Yeah, don't place it, because unless you come up with a specific plea that the work, there is a difference in degree, the work performed by them is not equivalent to the work performed by these people. So unless that, this is just this is just a principle. This is just a principle.
Yes,
It
Your
need not be applicable to all cases. All right. So
Your
that
Lordship, but in this case, what has happened? The basis on which they are claiming that they should be given the pay scale of senior technical assistant is of a 1981 settlement made in the case of UC Burla. In that, why was Your Lordship? I'm asking a question to myself. Why was that settlement made? The settlement was made because the nature of duties of junior instructor and senior instructor were taken to be similar. Now, in this case, they have not provided any document which says that the nature of duties of junior technical assistant and senior technical assistant are similar. They have provided recommendations of Vice Chancellor of BPUT. As per that recommendation or that report, it says that the nature of duties of junior technical assistant in IGIT Sarang and junior instructor in UC Burla are similar. So, but their prayer is that they should be given pay scale of senior instructor. But they have provided documents which says that the duties of two different posts of two different colleges are similar. They have not provided any document to say that duties of the junior technical assistant in IGIT Sarang and senior technical assistant in IGIT Sarang are similar. There is no such document.
all right.
Sir, page
Brief
29.
reply, Mr. Mahathir. Very brief.
Page
reply.
29. Page 29,
Yes.
second para. The board of the IGIT Saranga, including the principal. The board discussed on the representation of teaching assistant, junior assistant, technical institute on equalization of their pay scale with that of the employees of UC Burla. having identical qualification, experience, job assignment. Who is saying this? He is saying by the board of the governors, including the principal. Now the principal is now taking a stand, false stand that nowhere we have said that the job assignment equal, everything equal, nowhere.
All right. Hearing concluded, judgment reserved. ସେଦିନ ସରି ଯାଇଥିଲା ଖାଲି ଆପଣ ସାରି ଦେଇଥିଲେ ନା ସେଦିନ ନାଇଁ ସରି ଯାଇଥିଲା ନା ଆର୍ଥର ଆପଣ ସାରିଥିଲେ ଲାଷ୍ଟ ମୋମେଣ୍ଟ ହି
My only point to add here, my lord, if it is
yes
acceptable. Lordship, these petitioners, they had earlier approached before this honorable court.
Yes.
They were granted with an opportunity to file a comprehensive representation, and that representation shall be considered at the level of the then industries department. My lord, the representation is at unnecessary proceedings. Also, verify that it is an admission of the petitioners that there is a post of teaching assistant where they are continuing. There is also the post of senior teaching assistant. There are 3 number of posts of senior teaching assistant also. That is in page number 16, para number 1. So, my lord, there are 2 types of posts which are existing with 2 different scales. Now, what is the prayer in this case? To quash the annexure 4, that is the decision of the government, and the teaching assistants having 5 years of experience as such may be brought over to the cadre of the senior teaching assistant. The posts are limited, my lord. They cannot be brought over, my lord, all. That is why consciously they have stated that since, however, here only 3 sanctioned posts of senior teaching assistant, and none of us can switch over to it due to want of vacancy. So, my lord, the hierarchical post structure, my lord, the base post is always more in comparison to the upper level post, my lord. So, it is not that a person can, here, my lord, my limited point is that, my lord, that he has a right of consideration, and for that, my lord, there is a post. Now, what he wants, my lord, that because of the similarity nature, what it has been granted sometime in 1981, by that time, my lord, in 1981, this institute was also not in existence. So, to give me that parity of that particular benefit. So, that was on a different context. And here, my lord, the post is there. There is a promotional avenue. And the petitioners claim that, my lord, because of limited number of vacancies, the chance to get the promotion and to get into that particular post, my lord, that is limited. So there are the background of facts are also, my lord, different in this case.
Will you file a note?
But I will.
Or
Your Lordship, one last submission.
hearing concluded, judgment reserved. Parties may file the note of submissions and memo of citations, if any, within a week. Yes. No further submission. I have heard enough. Yes.
Thank
No.
Not 12. May I please, sir? Seven 1094. Pursuant to the letter of the under Annex 3 of the writ petition, the school under Dhenkan Circle declares that the government eligible for granting it since during Ekalave and Boyalave, government pleased to concur the payment of granted with effect from Ekcha. Prior to that, they have taken an undertaking in 5995 that you have not claimed that salary prior to Ekcha. That is 91 to 94. That in that period, I have filed a writ petition that is transfer 15/2000 to quash the illegal undertaking, which is unconscionable, that is illegal in IF law, violate the section 23 of the Contract Act. So I want to quash that undertaking, but unfortunately, due to non-appearance to the lawyer, that has been dismissed for different years. Then this present petition, thereafter I have made this present petition in 2012. I have filed. That is in a subsequent. This is a case cause of action because
they have discriminatory giving that granting it to the other similar institutions have cited in my para 11 of the discriminatory submission. They have given that is the granting it with in the year of 2011 and 12. They have that's the discriminatory one. Taking into that discrimination, I filed this petition. If that granting aid is allowed to some other institutions in similar situation, then why not us? This is the prayer of my ground. That elite court, it is settled question about that elite court can interfere when action of the authority is discriminatory. This is the discriminatory instances.
Yes.
Yes, ma'am. On 6/4/2024, my lord. In fact, my lord, we had filed one additional counter affidavit, my lord,
Yes.
for serving a copy of the
Yes,
senior
yes.
issue, my lord. There we have specifically stated all the points, my lord.
Yes.
And not only this writ petition, this petition is also approached before this honorable court on different occasions with different prayers. But in the year 2006, when the original previous writ petition with the same prayer, my lord, and if in the previous case, my lord, in the 2006, there is another prayer with respect to quashing that undertaking and other things, my lord. I don't mind, my lord, these are not the prayers, my lord, in this case. So, my lord, since I am limiting my submission to the prayer, what it has been made in this case, my lord. So that this is also one of the ground, my lord, that when he has considered to a particular proposition and he has accepted that, and that has not been disputed, then the financial benefit in shape of area for such a long period, back period, my lord, is not sustainable, and that we have also relied upon the Tersensin case, my lord. In addition to that, my lord, yesterday, my lord, I have been provided with some more information that in similar cases, my lord, there were cases where there is a direction for consideration of the grievance of the petitioner in those writ petitions by the competent authorities. And they are taking into consideration the liberty granted by the honorable courts. In all similar such type of cases, my lord, it is what they have stated, the Court of TO, my lord, stated that these type of cases, my lord, they have rejected. And they have also given me in respect of one example, my lord.
We'll take it up after vacation. Heard
So,
further
may I
further
complete
arguments.
it, madam?
No, it will
Since
come
I
on
have-
the reopening day.
No, no,
Come in the reopening.
since I have this information,
Yes.
I'm just sharing it. So that I can make a.
Heard further arguments in part. Place this matter on reopening day 18 June. Yes. 20th June. 20th June. 20.
I don't know, 13.
Yeah, this also.
Have already heard.
No, this is also let it come on 20th June.
And completely, yes, sir.
No, I cannot deliver judgment. So let this matter. Heard further arguments in part. Let this matter on 20th June. Yes.
I don't know, 14.
Here in this case, my lord, before, sorry. My lord, on the last occasion, my lord, I undertook to provide the copy of the guidelines regulating the manner in which, my lord, the ASA Kormis, they're getting appointed, and that is available in the net, man. But so far, the procedure, whatever it is required to be taken at the time of disengaging or de-recognizing them, my lord. My lord, actually,
Yeah, I find that since morning you are disturbing the court, sir. Very unfortunate. This is the second time that the court is saying. Sir, may I request you to kindly leave the court, sir? Please, sir. Please retire from this court. What? Why are you talking with him? No. This is very, very bad. You are an officer of this court. How can you behave like this?
so my lord, I need some time, my lord, to get that instruction. Because
Instruction about what?
with respect to that, what are the modalities and what is the guideline which is in force while de-recognizing or disengaging one ASA Kormi, my lord, on some ground or other.
All right.
I have contacted also Mr. Vibhu Tripathi, my lord, who usually appears on behalf of NRHM. Here, my lord, NRHM is not a party.
Doesn't matter.
So, my lord, I will collect the info.
Listen, Patnaik Leonard, AGA
Say, net or something else.
submits that he has sought for the instructions of the government regarding the modalities to be followed for derecognition slash disengagement of Asha. Hala. He requests some time.
Yes.
Raise this matter on 26th June.
26,
27.
छुट्टी पूर्व
Hmm?
छुट्टी पूर्व और डेट है
No, 26th June. Yes. I don't know, 15.
yesterday my lord, I have given judgments.
Yes. Sir.
Yesterday the matter was heard and
I was directed to place the matter. My lord.
कौन matter था?
My lord,
it's not
this is
to draw
matter.
100% block grant matter. The
Yes.
similar benefit is already extended to other employees.
Is it covered by the judgment?
Your lordship order, my lord, they are relying upon. But factually, it is actually in different, my lord. Different. And that is how it is different that we have discussed in our law.
Then let it be heard.
I
Let
have
it be heard.
already solved a copy, my lord, and they have not also filed any reason to repeating the same.
So let it be heard finally. Yes.
Matter.
Yes, place the matter.
The counter came. The day before tomorrow, I received mail. I have not gone.
Because yesterday, my lord, Mr. Swamidas, actually, after going to the counter, he told that since I am relying upon these decisions, so
That is-
actually it was my responsibility. I was directed to say,
All right,
and
as
I took
requested
time
by-
for today.
As requested by learned counsel for the petitioner, place this matter on 26th June. Yes. Account 16.
Item 16, I prefer pass over. My lord.
All right, pass. Account 17.
Lordship, I'm appearing on behalf of Mr. SB Jana. Lordship, on the last occasion, your Lordship has directed the government council for filing an affidavit.
Yes.
Yes, an affidavit is being filed, hard copy may kindly be accepted.
Yeah.
Showing the difficulties for which he could not get the records, he has given this affidavit seeking 8 weeks' time.
लिखो in order dated 3/5/2024, the word representation occurring in paragraph 6 be corrected as affidavit. ମୁଁ ଡାକୁଛି କଣ ଲେଖୁଛ ତମେ? କଣ ଏଥିରେ କହିଛନ୍ତି?
He has stated the reasons for which he is seeking time. Yes, paragraph 8, 9 and 10. 10 he has sought for 8 weeks' time to apprise, give the necessary affidavit.
As directed, the block education officer of Kolavira.
Kirimira, your Lordship. Sorry.
Kolavira, holding additional charge of block education officer Kirimira, has filed an affidavit inter alia requesting for grant of 8 weeks' time in order to collect the required documents / papers to examine the prayer of the petitioner regarding disbursement of family pension. This is a case of the year 2010. And the matter involves family pension. Stop. However, considering the fact that the present incumbent has has taken charge recently, not only recently, has taken charge on 31/8/2023 in the absence of the regular person, I am inclined to grant time as last chance to him to furnish the necessary records, public documents. Place this matter on 26th June. Yes.
Oblige your lordship.
The previous order be Item number 18.
Madam, filing requisite resource notice, appeal number 3, notice has been issued. When the matter relates to the release of the financial benefit from the date of.
Requisites were filed.
Yes, yes, notice also issued. That
Notice sufficient.
there is a noting.
Item on hold now. Item on hold. Door locked. Door locked is. Notice sufficient.
Notice to the principal of the college.
So it
That
says,
was the order.
postal tracking report says item on hold, door locked. Intimation served. ମାନେ ସେ ଖବର ଦେଇଥିବେ ତାକୁ ଯେ ଆପଣଙ୍କର ଗୋଟେ ଚିଠି ଆସିଛି ତେଣୁ so we'll take ଏଟା 7/5 ରେ ହେଇଛି we'll take it up next week ହେଲା
After vacation.
postal tracking report ନାଇଁ next week ଆସିବ ତାପରେ we'll adjourn it the postal tracking ଆଚ୍ଛା ହଉ the postal tracking report shows that the postal item is on hold as the door is locked. Stop. List this matter on 20th June. 20th June. All right. 19, the up-to-date postal tracking report be tagged to the case report.
Item 19, I have been instructed from the university to appear on behalf of the Chancellor, my lord. I take some instruction regarding these matters.
Lord, it's a
Let it
matter
be taken.
already
Next.
2 to 3 times hard by my.
2 weeks.
One second. Already hard. It's a question of regularization. Citing the earlier covered judgment, your lordship took note of the first statute and the rules that the regulation by relaxing this can be done with approval of the chancellor. Since chancellor was not made a party, only to avoid that technical snag, your lordship directed me last week that you implead chancellor. Accordingly, we took notice on the chancellor. So, Honorable Chancellor will have nothing to say on merits. Of course, my learned friend is appearing, he can take time to obtain instructions. But then he has nothing to learned.
No, the office of the Chancellor has not asked you to take time. No, Mr. Mishra. He says you are therefore requested to please appear and defend the case on behalf of the Honorable Chancellor through University Advocate and to update the Secretariat about further development in the matter.
My lord, next page, my lord. The register. On 30/4 ମତେ WhatsApp ରେ actually ପରଦିନ ମୁଁ ପାଇଲି.
You are therefore requested to take necessary step on behalf of the Honorable Chancellor in the Odisha High Court in this case referred above.
କପିଟା ବି ମୋ ପାଖେ ପହଞ୍ଚିନି.
कौन आया नोटिस एक लाभ रहा भूल पता
ନାଇଁ ମୁଁ କପିଟା ପାଇଲି.
You want some time, I can grant. We'll take it up next week then.
next week. Yes.
Next week. You are Mr. Hon'Ble Mishra.
Yes.
Mr. Hon'Ble Mishra. Your name is already there.
Yes, my lord.
He is
I am
appearing for the
appearing on
university. He is already appearing for the university. He is aware of entire thing.
Acha, how? Sri Hon'Ble Mishra submits that he has instructions to appear for the newly added opposite parties. The newly added opposite party number 5. That is Chancellor, Utkal University of Culture. You have not filed your Vakalatnama.
I have filed Vakalatnama on behalf of the university.
No. But for the Chancellor, you have to file a separate. Notice has been gone
They have
separately.
not, till now, they have not served me a Vakalatnama.
He undertakes to file the Vakalatnama by next week. Place this matter on
15 or 16 March.
No.
16.
16th May.
16 March.
Yes.
Okay.
Get ready.
Entry order.
Entry order to name Taku Puch.
Entry order.
Entry order to control.
Item 20, my lord, I am sorry, yesterday I could not point out that rules, UGC leave rules.
Yes, UGC leave rules.
Under annexure 9, my lord. My lord, running page 37 of the bill.
No, just let me read it. The commission worded its notification, revision of pay scales, minimum qualifications. Acha. Yes. So, kete kore rule 5.2.
My lord. 5B.
5.1B.
5.1B. 5.1 is earned leave admissible to a teacher shall be 1/3 of the period, if any, during which he or she is required to perform duty during vacation. I think this more or less seals the fate, apparently. The rules provide, yes.
Sir.
You, as I yesterday, I think I asked you twice, and you also fairly submitted that you are not disputing the fact that he had he had discharged rostered duty during vacation.
I'm actually accepting that, yes.
So if that is the case, so there is no reason why the government should be sitting over it. This UGC rule is there. Will direct the government.
But the objection is by the auditor.
No, audit, we'll ignore the audit. Audit is nobody. You know how these auditors work.
Okay.
Nobody knows it better than me.
Yes, sir.
So we will not consider that auditor. Audit finding, it is just a recommendation. It has to be acted upon.
According to the act, for the statute of the 21 statute, and in related to the local fund audit act, the procedure is that deputed by government, by the fund was.
So what is the objection of the audit? That he had not worked.
No. He says that prior to 1996, is there concept is there related to this vacation of the rostered duty. The rostered duty, okay, he has taken X number. So it should be divided by 3. So like that is the calculation is there. So here is that calculate I am in a particular year, my rostered duty is 13. So I should divide the 13 by 3. The 13 by 3 it should be a round off. Now how should I know? Now 13 4 point something. So it should be considered as a 4. It cannot be considered.
No. We are getting into unnecessary complexities. You see, the mode of calculation, that depends entirely on the on whatever has been provided in the rules.
Yes, sir.
Nobody can dispute it, and he cannot claim anything beyond what has been provided in the rules. Now the UGC rules very clearly says, as I have read out, earned leave admissible to a teacher shall be 1/3 of the period,
yes,
if any, during which he or she is required to perform duty during vacation. So this is to be calculated. This is to be calculated by your accounts department.
Yes.
But here what has happened is you have written to the government. I don't know why, but anyway, the government is sitting over the matter.
The government. Okay.
So I will direct the government to consider this and take a decision within, yes, what do you say?
My lord, this honorable court on 31/3/2021 directed the government to file the affidavit on that.
Government has not filed.
Now it is
my lord, I am the yesterday, my lord. I wanted to take adjournment, my lord, but your lordship denied that taken no further adjournment.
Not a question of adjournment, Mr. Patel. Kindly appreciate. You have been sitting over this. You means the government has been sitting over this recommendation or whatever this proposal since 2013.
No.
Huh. That
Since 2008, my lord.
2008,
My lord, since 2008, my lord.
all right, 2008. So if it is 2008 and now 16 years have gone by,
Yes, sir.
and you want 16 days time to act upon it, why should I grant you 1 day time?
My lord,
That is why I said I will not grant anything.
I consider.
So I will direct the government to consider.
Yes. And to
release
into
it.
consideration the UGC rules and other things.
Yes.
I
What
am
is it?
now 76 years, my lord.
That is all right. That is all right. So you have received EL calculated at 129 days.
Yes.
You are claiming it to be 152 days.
No. That is not. That is
Residual 150.
EL, my lord. This is for rostered duty I am claiming. 457 days means by divided by 3.
3.
It is coming 152 days.
Yes, it's here.
That I am claiming now.
That is what I am saying, that you are claiming 152.
My lord.
I may have wrongly said it EL, but it is actually roster duty. It
No,
will EL on account of roster duty.
Rostered.
Yes, ma'am.
My lord.
So that is what exactly I am saying.
Yes.
So now I will direct the government to allow it. Why should a government take a decision? Government will allow it in terms of the, because it is not disputed. That is what.
Yes.
Though this case, heard learned counsel, heard Sri P.K. Das,
Right.
learned counsel for the petitioner, Sri S.N. Patnaik learned AG for the state, and Sri Acharya, Mr. Acharya, Sir, your good name, please. Full name. Sri T.P. Acharya, Learned Counsel appearing for the university. Though this case has been pending for nearly 10 years, the point involved is in the year 2013, no action whatsoever has been taken in this regard by the government. Stop. This gross inaction is unconscionable in the law, unconscionable in the eye of law, particularly when one considers that this is a case where a long retired employee, long retired teacher of the university is seeking his legitimate financial benefits. So, considering the undisputed position regarding performance of roster duty by the petitioner during vacation for 457 days. This court holds him entitled to earned leave as provided under Rule 5, Rule to 5 means paragraph 5, bracket small b of the UGC leave rules.
Bracket Roman 1, then small b.
Right, capital 1. Yeah. Since at least 6 professors mentioned under paragraph 12 of the writ application have undisputedly been given the benefit, depriving the petitioner of the same would amount to gross discrimination and thereby be hit by the principles of equality enshrined under Article 14 of the Constitution of India. For the foregoing reasons, therefore, the writ application is allowed by, we will have to quash these by quashing the, where is the rejection? By quashing Annexure 2 series.
That 19.2 letter is the.
Annexure 2 series का quash कौन करेगा? Annexure 2 series does not need to, it is not against you. Why should it be quashed? They only said that we are waiting for the decision of the government. Nobody has rejected it. You will simply be issue a direction.
Yes.
By quashing, by directing the university authorities to disburse, to allow encashment of leave salary and other dues of the petitioner as admissible under Rule 5, bracket I, bracket small b of the UGC leave rules mentioned above. Since the petitioner is a retired employee and is said to be presently aged about 76 years, this order shall be carried out as early as possible, preferably within a month, within 6 weeks from the date of production of certified copy of this order. See, the government pending will say it is deemed to have been allowed. In view of the rules of कौन?
नॉले एमिति भी कराई परियो से जो ऑडिट रिपोर्ट रो ऑब्जेक्शन को भित्ति करके जिनसे होई पास दी परना तुल कुछ दैट ऑडिट रिपोर्ट ऑब्जेक्शन में भी हो
I did not deliberately refer to that audit. I did not deliberately refer to that. I simply went by that. What audit? What audit? You have given it to other persons.
No, actually, university is taking a plea saying that, my lord, because of that audit report, we are not in.
अच्छा वो लिखी जोंदो कोटे जागा
So that is
What
what,
I
my lord,
left
that
out
will be
there.
clarified so that.
it is submitted that because of objections by the audit also the benefit could not be granted. So this court is unable to accept the contention as above for the reason that if such was the case, then the registrar could not have sought for clarification from the government without mentioning anything about the audit report. Could लिखा है चित्र? Could लिखा तो है? Annexure B by 2 रे? Audit को था लिखा है? So even otherwise, the audit report, the audit, it is right that the audit objections are not the last word in the matter. And this court finds no evidence of any further action being taken pursuant to such objections. Therefore, such objections need to be waived. That's all. Yes. I will arrange the order accordingly. Yes.
Item 21.
Matter on behalf of Mr. N. Linka, this matter kindly taken up next week. In the meantime, rejoinder will be filed.
Very simple matter in this.
The last time you have taken time. You have filed a complaint.
Counter, I have file copy also.
On time, once or
Kindly fix the date.
by 11
But
council.
second item has already been rendered infructuous.
एकाठी असू दे जातो. Therefore, adjournment is made on behalf of the Lanka council, the petitioner, on the ground that he would file a rejoinder. Place this matter next week. Na vacation पर करता.
Matter to come next week. Kindly fix the date.
नहीं, let it come after vacation. Why so hurry? 2015.
बहुत दिन वाला ना हरी किसी नहीं.
20th June.
28th June. Rejoinder, if any, be filed in the meantime.
Item 22.
Just take what it is. Just now, my lord, I came to know. In fact, my lord, on the last occasion, as per your lordship's direction, I had actually filed two affidavits, my lord. One is by government, another is by collector. That's sacrament to do. How she could sign a document subsequently by saying that she was not.
Action has been taken?
No. Though the draft charge has been submitted by the government, my lord. ମୁଁ mistake ଟା କଣ
नहीं ଆପଣ affidavit file କଲେ?
ମୁଁ affidavit file କଲି।
କୋଉ file କଲେ?
ସେଟା ମୁଁ last
affidavit
last date ସେ କରିଥିଲେ।
ସେଇ copy serve କଲି କିନ୍ତୁ unfortunately in copy of the petitioner, my lord, what I did, my lord, the index page is changed but internal page is on extra.
But there is no affidavit on record.
But on the last occasion, I physically.
On 25th of April, it was filed in the court. Last date. On the last
Habib Mohan Murmu.
ଆଜ୍ଞା ଆଜ୍ଞା ଗୋଟେ କଲେକ୍ଟରଙ୍କର ଗୋଟେ
କଲେକ୍ଟରଙ୍କର କଲେକ୍ଟରଙ୍କର ନା
ଆଶିଷ ଠାକରେ
where is that
ସେଟା ହଉଛି 29 ବୋଧେ ସ୍କାନିଂ
ସ୍କାନିଂ ହେଇନି ଦେଖିଲ ଅଛି କି ଇଏରେ
ହବିବ ମୋହନ ମୁର୍ମୁ
ସ୍କାନିଂ ବୋଧେ
under secretary.
Yes, Hobby Murmu is one of the affidavits, my lord. And another affidavit is by Ashish Thakre.
Legally? I am more interested in the collector's affidavit.
ମୋ ପାଖରେ ଯୋଉ କପିଟା ଅଛି ଦି ଜଣଙ୍କର ଠିକ ଅଛି। Unfortunately, I went through that document, my lord. ବୋଧେ ମୁଁ ଏଟା ଉପରର ଇଣ୍ଡେକ୍ସଟା ଯେତେବେଳେ ବହୁତ ଗୁଡେ ହେଇଛି ସେଦିନ ଉପର ଇଣ୍ଡେକ୍ସଟା ଆଉ ଜଣଙ୍କ ସହିତ ଲାଗି ଯାଇଛି ଦିଟା କପି ଗୋଟେ ଥର ତାଙ୍କୁ ସର୍ଭ କରିଦେଇଛି ମୁଁ within the course of the day
ପୁରା ଲାଷ୍ଟ ଥିବ ପୁରା ଲାଷ୍ଟ
ସେଇ ଗୋଟେ ତ ନାହିଁ ନାଇଁ ଆମର ୟାର ଖାଲି ଦେବି ତ କଲେକ୍ଟର ଦେବି ଏଇଟା ଅଛି ମତେ ଆଉ ଫେରେଇବା ଦରକାର ନାହିଁ ମୁଁ ଦେଇଦଉଛି ଗୋଟେ ମୋ ପାଖରେ ଏକ୍ସଟ୍ରା ନାହିଁ ତ ମୁଁ କରିକି ଦେଇଦେଉଛି
ମତେ ଠିକ ମିଳିଛି
ନା ମୁଁ ସେଦିନ
ମତେ ଠିକ
ନାଇଁ ନାଇଁ ସେଟା ମିଷ୍ଟେକ୍ ତା ତରତରେ ଆସି ସିଗ୍ନେଚର
ଏଇଟା ଲାଷ୍ଟ ଦିନରେ ଆଫିଡେଭିଟ ଟା ଖାଲି କାଉଣ୍ଟର ଆଫିଡେଭିଟ
ମିଳିଗଲାଣି ତ
No, she was asked to show cause.
No,
They have enclosed it.
that is the proposal.
Yes, so cause has been filed.
Proposal to government.
that is the lordship is referring to government copy.
No, I've got your copy.
Yes. So my lord, the collector has prepared a draft charge, my lord. And but my lord, thereafter, with the on the basis of the subsequent correspondences, they're actually not finding any further material to initiate a proceeding, my lord. My lord, that is what they have also clarified, my lord. That under the threat of that particular person, my lord, she had and she has submitted my lord,
No,
explanation.
if she was threatened by somebody, she should have, she being a government officer, she should have lodged an FIR. If she did not, it proves, or rather one can presume that it's a false statement.
My lord, may I be permitted to give the facts, my lord, in not sell, my lord.
But that has got nothing to do with.
He has not solved the copy. Copy of the affidavit of the collector. I am filed only one reply to the affidavit of OP number 1. But the collector has filed the affidavit.
But anyway, that is the other thing.
Yes.
The question is, we will, if it is admitted
With respect to the fact of the case, my lord, because there was a direction of this honorable court, my lord, in the previous occasion.
Oh, this court wanted to know what action was taken. The collector says, as directed by the court, we have taken action. No.
Prior to this filing of this writ application, my lord.
I am actually making a submission, my lord, on the fact of the case, my lord. Not on this particular case. My lord, there is a direction. Previously, my lord, there are two persons. One is unsuccessful, another is a successful candidate. My lord, on the behest of the successful candidate, unsuccessful candidate, one petition was filed. Thereafter, my lord, because she didn't get any appropriate order, a writ petition was filed. Thereafter, my lord, on the basis of the particular decision, when another type of order was passed, then another set of appeal and a writ petition was filed. And ultimately, my lord, in the previous case, the impugned order on the basis of which, my lord, this is present impugned order is challenged, my lord. There was a direction to conduct an inquiry.
No, I have not challenged the impugned order. There is no any direction for inquiry.
So, on that,
the honorable court directed to quash the impugned the order of the sub collector and ADM and director here on the ground that they have taken a plea that he has not given the opportunity of hearing. He is absent, is passed the order.
So, my limited submission, it is completely on the actual basis that whether that particular this present petitioner is belonging to that particular service area or not. This is purely a factual aspect, man. And my lord, other than that, my lord, there is no allegation. So whether she belongs to or she doesn't belong to. My lord, since the inquiry report, which is the basis to reach to such a conclusion, is now doubtful. Before your lordship, that is now doubtful. May I pray, my lord, this matter may be, it may be there, my lord. It may not be disposed of. A date may be fixed, and before that, my lord, a responsible officer, senior responsible officer may be directed, just like in the other case, my lord, in that Mojipada area case.
Directed
to RDC. But here, RDC is not required because the collector up to the sub-collector, my lord. The present sub-collector may be directed to conduct an inquiry and to place a report before lordship, so that everything will be sufficient. Because it is purely on factual basis. And my lord, I don't think my
sub-collector is now passed the order. Any officer other than the
ADM? Yes.
What do you say, Mr.? I think it's a fair submission.
My lord, actually, the writ petition become infructuous now. If your lordship may peruse the prayer has already been become infructuous.
Why?
Because the prayer is, your lordship may peruse, rule of Nisi to the opposite party to show as to why had inquiry report dated 14/9/2016 shall not be quashed, and why OP number 2 shall not be take decision as per this honorable court's court's order, and on failing which that order has already been complied with, my lord. Earlier direction of this honorable court order has already been complied with, and the sub-collector has decided the matter finally. Your lordship may peruse, I have given that
Sub-collector's order
at annexure A/4 in my counter, my lord.
You do one thing. You may challenge this order by amending your writ application also. Because an order has been passed pursuant to direction of the
appeal provision.
An order has been passed.
On the basis of the third inquiry report, which I have challenged during pendence of the case.
This is the
During pendence of the case, the software passed
it
the
is impugning this annexure 13. That is why I am submitting. When this order was passed under annexure 13, at page number 48.
Okay. Oh, the third inquiry report.
Yes,
I remember. No, it has not become infructuous. No, it has not become.
That is the prayer in the.
No, it cannot be said. Because the basis on which the sub-collector has passed the order is this annexure 13.
Yes, madam.
And
that annexure 13 is under challenge.
Under conclusion, the suppression it is subject
That
to
is why
final
I am
decision of
submitting.
the High Court.
That is why I am submitting. Since it is purely on factual aspect. So now whether this particular person is actually belonging to that area, A gharar loko to se gharar loko,
inquiry report gone against the petitioner.
No, not that.
She is not belongs to that particular area.
See for the moment, page 47.
No, why should I get into that?
No, see for the moment, page 47 of the arise comment of the CDPO. Same CDPO. Page 47.
That is what is under dispute now.
No, it is not disputed. That CDPO, he has submitted a report before the sub-collector by saying that it is worthwhile to mention here that the residential house of both the petitioner and the opinion fee belongs to the service area.
that is why, my lord, and she is also the Sakamani to do is also the deponent before your lordship in the counter. So that is the reason, my lord. I pray.
And in the counter, the same CDPO said the order passed by the sub-collector is wrong.
We can direct the collector to cause another inquiry.
ADM.
ADM.
Yes.
ADM.
That is one.
Under the guidance of the collector.
Yes.
The guidance of the collector. Because this is simply a factual dispute, as you said.
Completely, ma'am.
As directed.
On the 29/7/2016, a joint inquiry was conducted. In that joint inquiry, at the time of joint inquiry report, the Tahsildar has now informed to the Anganwadi Report 1 and 2. At that time, the CDPO 1, Sagarika Mahathi, he was there. He is the CDPO on 29/7/2016. As there was some mistake, she has not signed in the inquiry report. Subsequently, on 14/9, A2 has signed on the pressure of the Tahsildar. Therefore, he has signed that by mistake I have signed in the inquiry report. On the basis of that inquiry report, the sub-collector now has passed the input order. But in the previous inquiry report, the inquiry they said that I am belongs to that area.
No. I'm saying I will direct the collector or the ADM to have a de novo inquiry, completely ignoring the previous report.
Yes.
Let the matter be. As directed, the collector has also filed an affidavit. Counter affidavit, actually. Filed an affidavit. Inter alia stating that draft charges have been framed against the concerned CDPO and referred to the government for approval. Another affidavit has also been filed by
Collector, government matter.
by one Habib Mohan Murmu, the Under Secretary to Government in W&CD Department. Stating that stating the fact of submission of the draft charge proposal by the collector to the government. It is further stated that as the matter requires greater investigation and inquiry, it is under investigation of the government. It is under examination by the government. Stop. After hearing learned counsel for the parties at length, this court feels that the basic dispute involved in the case revolves around the residence of the petitioner and opposite party number 4 vis-a-vis the service area of the Anganwadi center in question. The matter has been inquired into several times, but the findings are inconclusive. In order to put at rest the controversy once and for all, this court feels that a de novo inquiry should be conducted into the matter by a senior officer of the government. Senior officer. This court therefore directs the ADM Baleswar to conduct a de novo inquiry to ascertain the residential status of the petitioner and opposite party number 4 vis-a-vis the service area of the Anganwadi center in question, without being influenced by the previous inquiry reports. Such inquiry should be completed within 4 weeks, and the report thereof be submitted within 8 weeks, and report be submitted before this court. Stop. Place this matter on 8 weeks. July date karo?
18th July.
18th July.
Yes.
I want to point out one thing.
Yeah.
The Lordship directed to cause an inquiry by the ADM. ADM is the appellate authority, Lordship. If anything will done, appeal will go to them. And I want to point it out.
So collector kar de. Collector kar de. Let the collector do.
And the residence of opposite party number 4 is not disputed. Residence of
so let him say that. Let him say that.
Because she is getting the benefits from
Anyway, let him say that. Yes. Free copy of this order be handed over to the State Council for compliance.
23, your Lordship may kindly look to your Lordship's order dated 1/5/2024. And I am pursuant to that order, I am now ready with the 90,000 draft. If your Lordship permits, I can hand it over.
No, transfer application ko.
State sought for transferring one arbitration.
Oh, yes.
Arbitration proceeding from.
Yes.
And I would
the original draft
senior to give an endorsement.
Yes, it is endorse कर दे. हम received the draft को लिख दे.
थोड़ा memo देता है सर.
चीज़ लिख दे. तो condition तो पूरा type कर दे अपने कल से. The Shri A.R. Das, Leonard AG, hands over the original demand draft for rupees 90,000 to Shri K.K. Jana, Leonard Counsel for the petitioner opposite party in court, who receives the same after endorsing his signature on the receipt. In such view of the matter, nothing further remains to be decided in the transfer application, which is disposed of accordingly. Dita.
আমি ওটা ফাইল করি সেটা দিতে
Item 24.
Last date, your lordship directed my learned senior the state council to produce the record.
As the petitioner was never an applicant person to has produced the original certificate page. In order dated 25/4/2024, the word certificate occurring in paragraph 3 be corrected as certified. Receipt showing receipt, copy of a receipt. Further, the words showing receipt also occurring in the third paragraph be deleted. Original file.
Yes. Because here the crux remains whether she belongs to the service area or not.
Yes, Mr. Das.
Though a counter affidavit has been filed by the CDPO, but the records have not been issued.
No, original file was called.
चिट्ठी कर दीजिए ଆସିବ ସେମିତି ଆଉ ଛୁଟି ପରେ ଆସ ଏଇ ଫାଇଲରେ ଆମେ ମଗେଇ ଦେବୁ
State Council requests for an adjournment on the ground that he has not received the original file as yet. Is this matter? Vacation for a call. 27 June. The previous order be complied with positively.
Item 25. My lord, just now I received the affidavit.
In this case, my lord, in fact, there are some additional information which are provided to us with certain documents.
What are you filing now?
My lord, that is the reply to that. We had already filed our counter, my lord.
But there are three.
My lord, there are three cases. Although, my lord, the same things have been.
Three connected cases.
Connected. That is the reason, my lord, for which, my lord, I prepared in 3 numbers, my lord.
Shri S.N. Patnaik, Learned AGA, files additional affidavit. Additional counter affidavit. After serving copy on Shri Das, Learned Counsel for the petitioner in court, who wants some time to respond. List this matter. 27 June.
27 June.
Tirinta matter.
Item 26.
That 26 is the transfer petition.
Yes.
Transfer was filed from the from Hon'Ble to Bhubaneswar, and last occasion the mediation was there. Mediation report was there also.
Unsuccessful.
Unsuccessful. Both are agreed to in the matter of transfer.
Can't.
Actually, report matter. Last one, guys. So both the parties on the point of transfer they agreed, but on other point.
Let the council appear. Some council is appearing, Mr. Gopal Mahanti.
Yeah. Associate was there.
Let him say so. I will pass that order. I am passing it over. Then. Please inform. Pass over. If he says so, I will pass that order.
लिखी देले मत कर मोर
से लिखी जेंजे से मीडिएटर रो से ठीक बार लिखा है I'll tell you what has been written. You see. ये clearly लिखी तले ही तांदा. तक न लिखी से लिखी ले.
Husband nije raji
In view of the above facts, the petition wants the transfer of the case, but the opposite party also agreed with the proposal of the petitioner. Both the parties disagreed in other proposal given by mediator. So let it better say appear kari koi do. Yes.
Item 27.
Please inform me, Mr. Patnaik. If you can, please inform the any associate of Mr.
Hello,
Item 27.
on behalf of PSNI. In the last court, it was instructed to both the parties to obtain instruction whether
there is a possibility of settlement. Yes.
So my client has agreed here for mutual settlement.
Your lordship fix it after vacation, so that in the meantime, if we.
No, I will send it to mediation center. I will fix it to after vacation.
Yes.
In the meantime, you appear before the mediator.
Yes.
Learned counsel of the parties have obtained instructions from their respective clients expressing their willingness to explore the possibility of settlement through mediation. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear in pursuant to notice received from the mediator and to render full cooperation in the mediation proceeding. Place this matter, July.
Sir, 11th July.
11 July.
Item 28.
Is this Mr. Raut?
In this case, order passed by AGM.
Somebody wanted to file, and who is for opposite party number 6, Mr. M. Mahanti.
He has served a copy of his counter.
You are appearing?
Sir.
You wanted to file counter?
Sir, please pass over. Yes, Naik is in the other court, so pass over to second half.
Pass over. Second half to civil matters.
In this case, actually, counter is required by from the state.
And you have also not filed.
Not filed.
You have not also. This is a 2024 matter. Let it come. Counter affidavit has been filed by opposite party number 6. It is filed. So, state is any counter required to be filed?
You have to support the appellate order. That's all.
That's all. Yes, Mr. Naik is here. What is the dispute about?
My lord,
Residential area.
Selection of the on-the-road center 1. That is 2 on-the-road center in the village.
Chutti pare kare. Chutti pare kare. Mr. Naik. Mr. Naik. Chutti pare. Release this matter. What date kar diya? On 27 June.
27th June.
Yes.
Item 29.
29 है ला. February 2024. February 2024 तो बोला नहीं. आउट कहीं. Black Z कथा तो पूछी. Black Z लिखा है 2024. Could ऐसे देखें? मिला? ये तो दे स्कैन ही था. As requested, time is granted till end of May 2024 for disposal of the case.
The pardon. In that case, prior notice to petitioner. ये जो इनका था वो नोटिस तो करो ना.
ये क्या लिख दिया हो? ये जो इंक्वायरी का था करोगे?
To both parties.
After hearing both parties. You got it?
Item 30.
Sir, hearing कॉल से जो इंक्वायरी करेगी hearing नहीं जुए.
Item 30. Yes. Yes, item 30.
Item 30, my lord, I am on virtual mode, my lord, because I am out of Kartak, I am on virtual mode, my lord. My lord, here, your lordship, while disposing of this application which was filed challenging the order issuing NBW, your lordship clearly observed that regarding that for disposal of the bail application for the first or second hour, because your lordship on that date about to satisfy that he is entitled for bail, but because of the fact that this is an application under section 482 CRPC, and in view of the predicament, your lordship could not grant. But however, your lordship indicated that first hour, second hour, same day, and acquittal of the co-accused should be taken into consideration. But that first hour, second hour order, that part has not been reflected. Only that part I have sought for this modification application I filed.
Considering the submission, the prayer for modification is allowed to the extent of stating that the petitioner that within inverted comma the CRLMC is disposed of, directing the petitioner to surrender before the courts below within 2 weeks and to move for bail, which shall be disposed of by both the courts below on the same day. Remaining the remaining part of the order shall remain intact. Yes. I've said courts below and on the same day. Yes.
Item 31. May I please, Your Lordship? The modification for your Lordship directed to furnish 50,000 cash security, Your Lordship. But the person is a very poor person, Your Lordship, unlimited person, unable to furnish, Your Lordship. Some amount maybe.
Last time,
last time I've told
last time you said that the amount outstanding has been paid by the petitioner. I directed the State Council to take instruction.
Don't have the copy.
Now you are saying that
and that is also a fact that he has paid, my lord. After that also he is telling that some amount is between two brothers, your lord. Bappa paisa se nahi hitla boli claim kortla ki paisa mon nahi hitch. But sabu bond erika dela pari bi se kochi mo paisa kich baki rahi is. Dei sach sob paisa mo bond guda bi.
So what instruction have you obtained? Vacation for us.
My lord, some amount maybe.
No, vacation for us. We'll let it come after vacation. We'll see.
What security कर दे
नहीं problem. इसे तो कहीं हो activity भी लोग उसी कौन custody अच्छे दिन कौन
some amount modified.
So last time I had issued a specific direction to the State Council to find out whether the outstanding amount has been repaid or not. So how can I now pass another order modifying the previous order? Yes.
I will take instruction after.
By next week then. By next week. As requested by Land State Council, list this matter next week. The previous order be complied with positively.
And the 32, may please your lordship, I may be permitted to appear on behalf of Mr. Ikesha. Lordship, on dated 16/2/2024, Honorable Court directed the petitioner to surrender in front of the appropriate lower court, and further was in the judgment that the lower court should release the petitioner on bail on deposit of a security deposit of 1 lakh rupees. Lordship, we pray for modification of time as well as the security deposit of 1 lakh rupees is a lump sum. Petitioner is poor person and cannot afford that, Lordship.
No.
Petitioner is ready to pay 50,000. We sincerely pray, Lordship.
No. I am also sincerely saying that I will not allow it. Very sincere. You can't doubt my sincerity. Considering it is submitted that because of financial stringency, the petitioner is unable to pay rupees 1 lakh as directed by this court towards cash security. Considering the submission as above, the condition to deposit rupees 1 lakh is modified to the extent that he shall deposit rupees 75,000 towards cash security. 2 weeks further time is allowed to the petitioner to surrender. Yes.
Grateful, Lordship.
Item 33.
May I please, my lordship, last time the order was
Yes.
my lordship, I filed all the deposition copies and kindly be granted some time next week for hearing.
All right, let's this matter next week as well.
Copies of
the depositions we supplied to the State Council. Yes. It will come in the weekly list.
So item number 5.
Pass over item number 5.
Last occasion, Lordship directed the code below that whether the VC facilities are available or not.
Facilities are available. The code below has submitted a report, has intimated that facilities are available in the said court for appearance of parties virtually. Stop. List, none appears for the petitioner, list this matter next week. Yes.
So item number 16.
16.
That is with respect to that cancellation of the mini Anganwadi center.
Yes.
Anganwadi.
There was he had sought for Passover. All right, good Passover for it. The Passover for it.
Passover item number 26.
26. नहीं इसे तो अभी पासवर्ड कर लेता हूँ छाड़ दे अच्छा अच्छा पासवर्ड कर दे हाँ से देखते हो हाँ वीकली लिस्ट ऑफ
List item number 1.
Lordship, and for the appellant, my lawn is on his legs. Kindly pass over this matter after lunch.
All right, pass over.
Wise matters.
List item number 2.
Item number 2, on behalf of the bag and is permitted. There is delay of 11 days in filing the appeal. Let
control it over.
Delay.
Control कर दो. Who is Mr. Sahu?
Yes, ma'am.
All right. Third line comes with the petitioner. I record it. Third line comes with the appellant. And then it comes to the respondent on the question of delay. It is submitted that because of death of one of the close relations of the appellant, he could not instruct his lawyer appropriately to file the appeal. Stop. As a result, there has been delay of 11 days in filing of the appeal. Stop. Should I say that you have no serious objection? Should I say that?
So objection.
Considering the ground on which the delay is sought to be condoned, I'm inclined to accept the same. The I is allowed, delay in filing of the appeal is condoned. Let it be taken for admission.
Admission next week.
Next week, आपनकर कौन कोई admission? हम क्या appeal कर सकते हैं? हमें admit करूँ न करूँ हमें किम जाने? न करी परूँ? Ready for admission? Leave this matter next week for admission. नहीं ये 23 matter हो छुट्टी पर.
छुट्टी पर. Then we commence in 24th.
List this matter after vacation for admission.
Item number 3.
May it please your lordship. My plaintiff is the lady and plaintiff is the appellant against confirming judgment.
This has not been admitted, no?
Not admitted for admission.
2018.
Aଜ୍ଞା
2018.
ହଁ ବହୁତ ମ୍ୟାଟର ପଡିଛି ଏଇଠି କେବଳ ଦେଲା ପରେ ମେମୋ ଏଠି ଆସି ଯାଉଛି କୋର୍ଟରେ ଦେଲା ପରେ ଆକ୍ଚୁଆଲି ଆସେନି ଫ୍ରଷ୍ଟ୍ରେଟିଂ ମାନେ ସୁଟ୍ ଫର ପାର୍ଟିସନ୍ defendant
you are the plaintiff.
I am the plaintiff against a confirming judgment suit for partition and usual plea by the defendant taken is that there is a prior partition. These are the two things. Under issue number 4 trial court came to the conclusion that there is prior partition. Appellate court confirmed the same. Before I
so it's a confirming or not factual aspect. Why should I
no
admit it?
I'm your lordship knows by for repetition I am saying before I place the findings your lordship may kindly see my lord if there is a document my lord, it will lead that there is a complete partition by meets and bounds. There is no document, this is the finding. Then, my lord, amicable partition, second category, my lord, if there is no objection, it can be accepted.
But prior partition can also be proved through oral evidence.
No, oral evidence, but not on the basis of severance of status. Point of law 1 and 2. Severance of status, it is the finding that there is no document. By severance of status, it will not lead to complete partition by meets and bounds. But court below has held that there is severance of status. That is the finding. And
let us see.
Yes. And secondly, on that basis, Exhibit 7, the rested seat they have sold, that has been interpreted 62 Supreme Court or 63, that interpretation or construction of a document is a substantial question of law. Exhibit 7 has been put to my lord interpretation by holding that prior partition is reflected therein. I have taken second ground that it has not been properly construed and it has not been properly read. First is that severance status on that basis. Then your lordship may kindly see appellate court judgment, paragraph 5 first. Your lordship may kindly see.
Appellate court judgment, okay.
Yes, paragraph 5. Paragraph 5 रो next page टा हबो page 6 गोटे number अछि मो brief रे सेठी भी हजुर को पाखर थिबो से page 6 रो 10th line रे paragraph 5 रो next page टा page 6 top रे अछि.
Yes, the consolidation
10th line. My lord, the consolidation ROR stands marked as exhibit 6. Exhibit 1 to 6 are considered. It would suggest that the properties stand jointly recorded. But then such a joint recording in the RORs would not mean that there was no partition. If there is a document on partition, it could be referred to and relied upon in proof thereof. However, in absence from the conduct of the parties, the same can be ascertained, which is the settled position of law. If from the conduct of the parties, it would be suggested that there was separate mesh and severance status. That is not the here. What the properties, then the claim of partition is to be accepted. Notwithstanding the fact that it stands jointly recorded, in the instant case, PW1's mother transferred her interest under the sale deed 93, which is marked, this is Exhibit 7.
But you never challenged Exhibit 7. You never challenged that sale.
My lord, that subsequently it is filed. Another suit was filed. That should have been tagged together, but it is separately dealt with. That is here in the finding. Subsequently, another suit has been filed.
So it should have been, both should have been heard.
Yes, my lord, that is not there. And that finding, other things, evidence cannot be looked into here.
Cannot be.
But on that petition, it has been looked into, and trial court held paragraph 5, it has been looked into. Your lordship may kindly see.
So how can this court now, when a suit is pending relating to the validity of Exhibit 7, how can this court give a finding either way with regard to Exhibit 7?
This should wait till the This should wait. That part, that is another part. But question is, my lord, Exhibit 7 has been misread and misconstrued. Holding that there is severe.
Because ask any finding. Any finding relating to Exhibit 7 will be debarred.
That should have been tagged. Now also that can be done. That is to be tagged. That is what my lord rightly acted. It is subsequently filed. It is numbered here. Number is given in this judgment of the suit court, my lord. Number is given, and
so let them appear. If necessary, we'll remand it for. If necessary, let us see. All right. Let us see your substantial questions of law.
1 and 2, my lord. 1 and 2. Section 44 TP Act.
Exhibit 7, I will not. Exhibit 7, I will not.
So
only
one. 44 TP Act ground
no. So exhibit 7 will have touch kale asubidha habo. When you say that another suit is pending. No, say that. Setra kisi mana nahi hai. Heard Sri J.R. Das, learned and counsel for the appellant. Peruse the impugned judgments. Considering the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the courts below committed error of law in holding that severance of joint status led to complete partition by metes and bounds. So, issue notice to the respondents by registered post. Dijon to respondent of by registered post. No, respond. By registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. Is this matter on?
In the week commencing 15th July. 15th July.
In the week commencing 15th July. Yes.
I don't know for.
It will be difficult.
But that is to be tagged. Tagged.
No, you should have immediately. You should have filed a petition for tagging. Had it been rejected, you should have come up to this.
They filed a petition to look into the evidence that has been allowed. That is the figure.
No, Mr. Das, what you have done. You would have done. I mean, you must not have been the conducting counsel, but whoever, he should have filed a petition. Had it been rejected, then he would have come up in CMP before this court, and this court would have definitely allowed, looking at the nature of the dispute, which actually revolves around Exhibit 7. That is why deliberately did not touch
decree.
Yes.
Obliged.
It will be very difficult to pass an order. Yes, item 4.
Mate, please. The defendant number 2 is the appellant before this honorable court against a confirming judgment in a suit for partition declared.
Confirming judgment.
Yes, it's a confirming judgment. Suit was filed
for declaration of for partition, declaration that the defendant number 2 is not the adopted son of the plaintiff's father. Further, to declare that the compromise petition basing upon which a consolidation officer has passed an order is fraudulent. Those are the 3 prayers. The learned trial court formulated 6 issues, out of which 3 are common to the appellate court. While the learned trial court held that the plaintiff has failed to establish fraud, still went ahead to proceed with it and suit was decreed. So far as the compromise petition is concerned. So far as adoption is concerned, the learned trial court as well as the appellate court has held that the plaintiff, it is not the plaintiff's case that the consent of the mother was not obtained or fraudulently obtained. However, both the courts below has proceeded as if it is the case of the plaintiff that the person who adopted the present defendant, his wife has not given the consent.
Yeah, factual finding.
No, that's what I'm saying. But so far as the compromise, that is the crux of the matter. The compromise is concerned, which has been confirmed in a consolidation proceeding. That order has been acted upon by the plaintiff in another suit. Suit was decreed basing upon that compromise. After a period of 3 years, he comes and says that was obtained through fraud. And both the courts below have held that the plaintiff has miserably failed to prove fraud, yet passed the decree. That is
let us see the issues.
Your Lordship may kindly see the issues your Lordship will find in the trial court.
The family partition between Hare Krishna, Vibhuti and Vasanta. Let us come to the genealogy first.
If your Lordship sees page number, the genealogy is at the first page of the trial court's order.
Udayanath is the common ancestor.
Yes, he is the common ancestor. Vibhuti is the plaintiff, your Lordships.
Yes.
The present appellant is Prasanta, who is D2.
Hare Krishna and Uma is his sister.
Hare Krishna and Uma are the son and daughter of Udayanath. The plaintiff's grandfather is Hare Krishna.
That's all right.
Yes. And the plaintiff's case is that Prashant, who is D2.
So, wait. Hare Krishna had 2 children, one Surendra and one Basanta Kumari.
Basanta Kumari.
So, you are the son of Surendra. You are the plaintiff.
I am the defendant too.
Achha.
Basanta.
You are the son of...
I am the natural born son of Basanta Kumari and Niranjan. My case is that I am the adopted son of Hare Krishna. Now, Hare Krishna's grandson is plaintiff Vibhuti, who says I am not the adopted son. That is the third issue. The main issue, my lord, is the compromise. My lord, what has happened in the consolidation officer? Hare Krishna filed an objection in the consolidation proceeding. Hare Krishna filed an objection, Prasanto, Vibhuti, all of them filed a compromise petition. The plaintiff also. The plaintiff's signature is there in the compromise petition. Basing upon the compromise petition, consolidation order was passed in 87. Property was amicably partitioned in lieu of the compromise. In 91, the plaintiff files a suit basing upon that consolidation ROR against another third party. Suit was decreed. He enjoys the compromise. Then in 90...
So it's a question of approbation and reprobation.
Yes. Now in 92, he files a suit saying that the compromise is bad. The agreement, not the order. He has not challenged the order. The agreement, the petition, compromise petition is bad where his signature finds place. Both the courts below has said he has failed to prove the signature. Still partition is to be done.
On what basis?
Yes.
Let us see that finding.
That your Lordship will see page 67.
Page 67. Okay. Yeah, 67 is the judgment.
Yes, ma'am. The issue is page 69 if your Lordship may kindly see. Page 66.
Yes.
Your Lordship will see.
No, not even 69.
Internal page 69.
No, 69.
See portion of finding patch.
The internal page the 4.
Second line from the top.
Yes.
Whether exhibit B is a fraudulent one will decide the entire gamut of the dispute of the parties. Although the assistant consultation officer was a party to the fraud, has not been made a party in the suit, nor any suggestion has been made to this aspect, the consultation authority under section 10 of the Act is competent to do such, and no question to this aspect can be raised before any court except on the ground of fraud, which has to be proved beyond all reasonable doubt as it is a criminal proceeding. The plaintiff filed TS number 197 of 91, that is the 91 suit, on the basis of the partition before the Civil Judge Junior Division, passed the ex parte judgment marked as Exhibit A by 1. Therefore, the plaintiff is aware of the compromise petition in 1987, since Then he did not challenge the compromise order passed by the consultation officer, only filed the suit in 92, which is not within the period of limitation. The consultation officer have acted in conformity with the procedure by accepting the compromise petition allotment sheet, which is binding to the plaintiff and defendant until it is set aside by the authority empowered under the Act. And it operates as res judicata in the present suit. Then your lordship may kindly see the next page. Para 8 mal. In this case, exhibit B and C are the impediments hurdles before proceeding in the suit. Some of the hurdles are created by the judgment. Then your lordship may kindly see this question has to be adjudicated by the consultation officer authorities who have jurisdiction. Then internal page 11 mal. That is the last operating part. Page 10, paragraph 10, your lordship may see the next page. It starts with so in this circumstances. Yes. Internal page 12. So in this circumstances, the partition with allotment exhibit B ordered by the assistant consultation officer under A is no doubt true because the plaintiff has not been able to prove any fraud as it is to be proved like a criminal proceeding. But Hare Krishna being a father of the supreme power, then my lord, he decides the partition on merit. But he says he has not proved fraud and that order is valid, is true. That is the exhibit B, which is the order passed by the compromise agreement basing upon which the order was passed.
Sorry. Yes, then what about the appellate court?
Yes, your lordship may see page, my lord.
How the appellate court has dealt with this aspect?
Page 53 of your lordship's brief. Internal page 38 of the learned appellate court's order.
Yes.
Your lordship will see para 40 at the top. So far as the third point, whether the finding of the observation made by the learned court below in impugned judgment respect is sustainable in law. Your lordship, the last para operative portion is. Your lordship will see page page para 45.
Yes. Yes.
The learned court below, without properly appreciating exhibit B and C, erroneously held that the plaintiff was aware of exhibit C. It is pleading of the plaintiff that the cause of action arose on 8/8/91 when the plaintiff demanded for partition and came to know for the first time about fraud of defendant alleging plaintiff's father is not the son of Hare Krishna. So, what the learned appellate court has held is he has said that the learned trial court has committed an error in holding. However, it is a confirming judgment. And that observation, neither the finding nor the judgment was anyway challenged by the plaintiff before the appellate court.
Where are your substantial questions of law?
I completely bowed on that substantial question of law was not properly framed at the time of drafting.
What is your good name?
Lalit Kumar Maharana.
Lalit Kumar Maharana.
Maharana.
Lalit Kumar?
Maharana.
Heard Sri Lalit Kumar Maharana, learned counsel of the appellate. There was the impugned judgments. Considering the grounds raised, the second appeal is admitted on the following substantial question of law. Look onto whether, in the absence of, whether on the failure of the plaintiff to prove fraud as pleaded, and on the face of the order of the Assistant Commissioner or Khali Commissioner?
Assistant
Commissioner of Consolidation relating to the suit property, both the courts below were correct in
Assistant Consolidation Officer.
Assistant Consolidation Officer. Whether both the courts below were correct in holding that the property was liable for partition. That's all. Issue notice to the respondents by registered post, fixing returnable within 4 weeks. The requisites be filed within 3 working days. Call for the LCR. List this matter. July. 15 July. 24th matter.
We come in 29th.
29 July.
IA
आयर कौन अच्छे?
the operations and execution to file करें.
Execution case है नहीं?
No, but that is not there, but
Declaration commission has offered some.
क्या final degree का था अगले ये लिखी ना थे?
that is not there. But,
So let the final decree.
Yes.
Once the final decree proceeding starts.
Yes, ma'am.
You can come to the court with another IA, so this court will direct that the final decree will continue, but it will not be sealed and signed.
Yes, madam.
Now, ବର୍ତ୍ତମାନ ଯାହା ଆପଣ କରୁଛନ୍ତି ଏଇଟା ଗୋଟେ ରିଟ୍ ପିଟିସନ ରେ ଷ୍ଟେ କଲା ଭଳିଆ କରୁଛନ୍ତି ସେମିତି ହବନି ଏ ସେକେଣ୍ଡ ଆପିଲ ପରେ ଥାଉ ସେତିକି ଥାଉ ସେତିକି ଥାଉ How much time will you take, Mr. Das?
15-20 minutes.
No, I'm not, no bar on time. I'm asking because looking at the, we may begin now if you want.
Yes.
Or we will begin after recess.
As you will also desire.
Mr. Panak, you are there? This can be completed today.
Yes.
Mr. Das is saying he'll take 15 minutes. Isn't it? We will take it up then after. Why will we begin now? And okay.
Sir, after your launch after the first transfer.
List item number 16.
Maybe. A limited grievance position of court is that although the present petition of pursuant to advertisement as per Annex No. 1 is applied for the post of Anganwadi worker, and wherein it has been specifically mentioned that the applicant must be of a permanent resident of that particular area and vis-a-vis must be of that village, and accordingly this is applied. Now and after it was in the year 2014, 2 years thereafter, by in an illegal manner, the thing has been in a process of scrutiny. It has not been taken care of, and this thing has been totally, the list has been declared not actually the earlier advertisement has been cancelled, which is the subject matter of this application. Earlier, I have tried my best to convince my lord to this extent that because of the fact that because advertisement, it is the advertisement where it has been specified that the concerned person must be a resident of the locality, permanent resident, vis-a-vis, see, he is residing within the area, area of operation. Now, in the particular advertisement, it has also been mentioned in the last para, the last page, that a particular from this house to that house, this is mini Anganwadi area, and this advertisement is for Anganwadi worker as well as mini Anganwadi worker. My humble submission is because nowhere it has been said that mini Anganwadi worker and Anganwadi worker separately is not been dealt with in the application.
Reopening weekly, okay.
And one more thing, in the meantime, I filed.
No, according to him, the guidelines for mini Anganwadi workers do not cover this aspect. All other aspects are covered, but this aspect is
separate to the extent that my humble
that requires interpretation. We'll see. Heard further arguments in part. Is this matter on 20th June? छुट्टी भी तो judgment देगा ना काहे?
Item number 26.
Vacation is meant for. Vacation is meant for something else.
नहीं नहीं देही होगा नहीं बकर मुझे judgment पक्की रखी लगा लाभों को. Item 26.
Both party active.
Yes.
My lord, the husband has been agreed with the proposal for transfer of the matter.
All right. The report of the mediator shows that the mediation proceeding ended in was not successful. It is, however, stated therein that both parties agreed to the proposal for transfer of the case. Stop. The present application for transfer has been filed by the wife of the opposite party, seeking transfer of CP number 31 of 2023, pending in the Court of Learned Judge, Family Court, Hon'Ble, to the Court of Learned Judge, Family Court, Bhubaneswar. Transfer, the said case has been filed by the opposite party husband for divorce under section 13(1) of the Hindu Marriage Act. Transfer
of the proceeding is transfer of the case is sought on the ground that the petitioner, being a lady, has no source of income, and presently she is residing with her parents at Bhubaneswar. Stop. Further, she is also under treatment at High Tech Medical College and Hospital, Bhubaneswar. As such, it would be difficult on her part to travel to Hon'Ble, which is at a distance of 200 kilometers from Bhubaneswar, to attend to the case. Learned Counsel, what is your good name, sir?
My Lord S.K. Godnaik.
S.K. Godnaik.
My Lord.
Sri S.K. Godnaik, Learned Counsel appearing for the opposite party, submits on instructions of his client that he has no objection to the prayer for transfer being allowed. In such view of the matter, the transfer application is allowed. The proceeding in CP number so and so is directed to be transferred from such court to such court. Learned Judge, Family Court, Bhubaneswar. Co-court 1. Learned Judge, Family Court 1, Bhubaneswar is directed to issue notice for appearance of the parties. Thus. Follow.
List item number 5.
Weekly list follow.
Item 1, let's.
One the same. Where is Mr. Mishra?
Item 1.
Wait. Item 5. LCR achi? Where is the LCR? No. The LCR is not there. But I find LCR call for it. LCR must have been called for.
Generally, on admission of the appeal,
LCR is
used to call for.
Yes. Call for LCR 31 to print bound identification.
And
to confirming
judgment.
To confirming
Judgment. But one thing is there, which your lordship may appreciate, on the basis of which the substantial question of law has been framed. If I take your lordships to the order dated 30th.
But I think there are two appeals.
Two appeals. Two appeals, both were disposed of by common judgment.
Two different cell deeds.
No, one cell deed.
Why two different suits?
That was.
Declaration of right title and permanentization. CBO suit to file consent.
Okay. Oh.
My lord, 30th January 2019. The substantial question of law is like this. Whether the appellate court rightly refused to exercise the power to allow additional evidence. My lord may also find it in my notes also I have put it. Additional evidence by calling for volume number 26 of book containing registered cell deed number 5187 dated 22nd August 1984 together with the sketch map from the office of the district sub-registrar to resolve the conflict between exhibit 1 by A, the map appended to cell deed, and exhibit D by 1, the map appended to the certified copy of the same cell deed on the contours of the provisions contained in Order 41, Rule 27B of the Code of Civil Procedure. Here your lordship may kindly see the judgment of the appellate court, first appellate court, where the application for additional evidence was really urged. This has been rejected by the first appellate court, for which this substantial question of law has been framed, taking into the facts of the case. Yes. If your lordship will kindly turn to the judgment of the first appellate court, I will take your lordship to paragraph 15 of that.
Paragraph 15.
At the middle of it, the sentence starting, as it appears, a Xerox copy of map is attached to Exhibit 1. Exhibit 1 is the cell deed by the plaintiff. The appellant has obtained the certified copy of Exhibit 1 from the office of sub-registrar and produced the same, which is marked as Exhibit D. The certified copy of the map attached to Exhibit 1 and Exhibit D by 1 are not tallied with each other. Learned counsel for the appellant submitted that the map attached to Exhibit 1 is a fraudulent document in view of Exhibit D1. On the other hand, the learned counsel for the respondent submitted that Exhibit D1 is a fraudulent document. So, my lord, my respectful submission before this court would be that if a dispute about identity is concerned, and there the sale deed is very, very material document, and the original sale deed, that map which is appended to the original sale deed, and the map which has been obtained, that is certified copy of the sale deed, the map is attached to that certified copy also. And the appellate court finds that both these maps are not tallying with each other. And both the parties allege against each other that the map.
No, but sir, what was the dispute basically?
Basically, the dispute is about the boundary of the land.
No, so you are the vendor.
Yes. I said that I sold a distinct land for which I got permission from the BDA. This is not this land which I have sold. And then I got the certified copy of the sale deed to show that really this is the document. And that certified copy was obtained from the sub-registrar's office. Whereas they have produced a sale deed, the original sale deed, where a Xerox copy of the map is attached and it was produced and said that it is the original. Your document is forged. But if the dispute is of such nature, my submission is that a application was filed before the learned first appellate court. Your lordship knows that Order 41 Rule 27B to enable the court to pronounce the judgment, that is one part, or for any substantial cause. When two maps are there before the court and each of them are alleging that either of it is fraudulent, then the best course would have been to call for that document from the sub-registrar's office, because that will cleanse the issue that which one is really genuine. But that was rejected on the ground that with the available evidence, the matter can be disposed of. That is the.
Was it rejected on the date of pronouncement of the judgment itself?
Yes, my lord.
Normally, the 2127 is taken up at the time of final hearing.
27(1)(a), it has been distinctly said, if it is a question of 1(a)(a), then the matter can be taken up even before the pronouncement. But so far as 1(b) is concerned, because if it is necessary to enable the judgment, court to pronounce the judgment, or for any sufficient cause, normally application under Order 41 Rule 27B is to be taken up and disposed of at the time of hearing. So far as other applications are concerned, it can be taken up earlier also. This is the latest trend. Otherwise, previously it was always along with the hearing of the appeal. But here is a application under Order 41 Rule 27(1)(b). At the time of judgment, the learned court has rightly considered at the time. So far as the procedure is concerned, it has been rightly adopted. There is no dispute. But the learned first appellate court said that it is totally uncalled for and unwarranted. It can be disposed of with other evidence. even after coming to hold that these maps appended to a particular cell deed, one is the original, other one is the certified copy obtained from the sub-registrar's office, they don't tally with each other. That is the finding of the first appellate court, that it doesn't tally. If it doesn't tally, then my lord, it's not an ordinary question. Parties are throwing a document before the court for adjudication, and that is the vital document for the adjudication of the matter. One of the document may be fraudulent, forged, and the party can be prosecuted also for perjury for that reason. But despite all that, the learned,
He seems to have placed the burden on you that you should have called for.
that I filed the application before the
Para 18, can you
Yeah.
please place para 18? In the present case.
in the present case, exhibit D and D by 1 were marked, but no attempt was made to call for the register from the office of the sub-register. Your lordship rightly found it. That is the. But what my submission is that either way, if a party who could have called for a document, but at the time of hearing of the suit has not taken steps, that will be a question under Order 41 Rule 27A. Here my application is under B, 1B. What I intended to say that this document is necessary for the court to pronounce the judgment. That is the reason why the learned court has proceeded to hold that this is unwarranted. But if your lordship will see, I have one judgment on the subject, that is the leading judgment of the Constitution bench under Order 41 Rule 47 1B, that is 1963 Supreme Court 1526. There it was a question of date of birth entry in a document. In paragraph 16, my lord, the apex court has held, in view of what the High Court has stated in this passage, it is not possible to say that the High Court made the order for admission of additional evidence without applying its mind. It seems clear that the High Court thought, on a consideration of the evidence in the light of arguments that had been addressed already before it, that it would assist them to arrive at the truth on the question of Sitaram Reddy's age if the entries in the admission registers of the school were made available. It was vehemently urged by the learned counsel for the appellant that there was such volume of evidence before the High Court that it could not be seriously suggested that the court required any additional evidence to enable it to pronounce judgment. The requirement, it has to be remembered, was the requirement of the High Court, and it will not be right for us to examine the evidence to find out whether we would have required such additional evidence to enable us to pronounce judgment. Apart from this, it is well to remember that the appellate court has the power to allow additional evidence, not only if it requires such evidence to enable it to pronounce judgment, but also for any other substantial cause. There may well be cases where even though the court finds that it is able to pronounce judgment on the state of the record as it is, and so it cannot strictly say that it requires additional evidence to enable it to pronounce judgment. It still considers that in the interest of justice, something which remains obscure should be filled up so that it can pronounce its judgment in a more satisfactory manner. Such a case will be one for allowing additional evidence for any other substantial cause under Rule 27(1)(b) of the Code. Here the most can be said about these documents which were before the court. The cell deed is a very material document on the basis of which both parties claim their respective case. And the map appended to it, if both are not tallying with each other, and an application has been filed before the learned first appellate court. But my submission is that under order 41 rule 27(1)(b), the learned first appellate court should have at least called for that document. It was not very far. It could have been called within a week also, and the matter could have been taken up for disposal. Either of the parties could have been prosecuted for perjury. If somebody has committed a fraud, that will be detected. But instead of doing that, and instead of rendering a finding that this is the document which has been fabricated by a party, if the court comes to a conclusion whether that is a disposal in a satisfactory manner, because the language is that judgment in a more satisfactory manner, and the apex court also took into account that not merely because that the evidence which is already on record that is sufficient for disposal of the case, but for a more satisfactory manner, if a document is required, then in that case the additional evidence should be taken into account. With this short point, my lord, my respectful submission before would be, your lordship should be, that by allowing additional evidence, no party will be prejudiced either way at this stage. And once the document is called for, the appeal can be disposed of within a limited time. A fresh hearing can be done in the first appellate court also.
So you are essentially you are asking for a remand.
Yes.
The direction to the court, trial court, to the appellate court to call for that.
Call for that document through the
yes.
service.
Here, Mr. Patnaik.
Yes.
Yes, Mr. Patnaik.
Lords, I have prepared two date charts, essential for lordships to appreciate the facts.
I have given the note of submission also.
This
Copy to my lord.
This is what you have given. Submission of the appellant.
Yes, my lord.
All right. Two date charts, why?
There are two appeals and two set of that's it. That is why I am filed two written notes. One is 513 and another is 514. There are two second appeals.
513.
Again.
You have also given your note here.
Yes, sir. Along with that.
Very good. Yes.
Go to second. 13, 14.
Thank you.
Your lordship, may kindly come to the date chart.
Yes.
At 1963-64, the vendor, my learned senior's client, got that land through wasteland lease, 5 acres of land. Now, what has happened at that time for subdivision of land, BDA permission was required. So, he applied for BDA permission for subdivision of land and for alienation. BDA granted that permission on 10/7/1984 for subdivision of land, BDA granted, and subsequently on 22/8/1984, a sale deed was executed by my learned senior's client in favor of my client's father, Mir Said. He is no more. He was original in the suit. Subsequently, he has died, and legal heirs are here before you also as the respondents. In 84, the sale deed was executed. He kept mom for 14 years. 14 years. In 1998, he filed a deed of rectification immediately that there is some error in the sale deed. And in the meantime, what has happened after purchasing the land in 1988, I have mutated my name in the revenue records. I got patta and constructed a house. I am staying there. After 14 years, he filed application for rectification unilaterally without taking my consent, and thereafter created disturbance by initiating a 144 case there and created disturbance over my land. Therefore, I filed a suit for declaration of right title interest and permanentization. The learned trial court decreed the suit in my favor in one suit, that is 611. Lordship, make a note.
Yes.
That is 611 by 2000. That is Mir Said alias Said versus Sheikh Muhammad Ali 611. And that is RSA number 513. Lordship mechanism. That suit was declared, and on the other hand, they filed a suit. That suit is 765 by 2000, filed by Sheikh Muhammad Ali, father of the present appellant, in the court of civil judge for declaration that I am not the owner of the land which has been purchased by me. Negative declaration. My suit was decreed and their suit was dismissed. And they carried appeal to the learned appellate court. Appellate court confirmed all the findings given by the trial court, and the concurrent finding of fact dismissed the appeal. Now, your lordship may kindly come to the findings of the trial court. I put a 13 about that. I put a 13.
It is there in your notes.
My Findings of the trial court. Your lordship may kindly come to paragraph number 20, page number 25, paragraph number 17 of the trial court. Page number 25, paragraph number 17 of the trial court. Findings of the trial court. 611 जो 513 टका अगर सेकंड है
इंटरनल पेज कितने?
Paragraph number 17. Paragraph 17
Internal page 25.
Internal page 25.
Yes.
They have raised a plea that suit is not maintainable, and paragraph number 2, paragraph number 7, issue number 1 is held that suit is maintainable because the findings given in issue number 2 and 5, and the suit has cause of action because the southern boundary of the land of the plaintiff has been attacked by the defendant, resulting criminal case. So issue number is answered in favor of the plaintiff. So far as southern side boundary is in dispute, which has been raised by the defendant, that has been decided by the trial court, and that has also been confirmed by the appellate court. So far as issue number 2 is concerned, sale deed was 1984 and his boundary was given, and there is existence of land of boundary shown by the parties with reference to sale deed. And so in the opposite provision of law 26 of the Specific Relief Act, I may permit to place, they are saying that there is incorrect description of the sale deed. So boundary, so it needs rectification. Section 26, if a lawsuit will permit, will place, when the instrument may be rectified, when through a fraud or mutual mistake of the parties, a contract or instrument in writing, not being the article of association of a company to which the Companies Act applies, does not express their real intention, then either party of this representative in interest may institute a suit to have the instrument rectified, or the plaintiff may, in any suit in which any right arising under the instrument is in issue, claim in his pleading
that the instrument is be rectified and the defendant in such suit as is referred in clause B may in addition to any other defense open to him as per rectification of the instrument. If in any suit in which a contract or the instrument is sought to be rectified under subsection 1, the court finds that the instrument through fraud or mistake does not express real intention of parties, court may in its discretion direct rectification of the instrument so as to express that intention, so far as this can be done without prejudice to rights acquired by third persons in good faith and for value. So in this case, what has done, they have, after 14 years of the execution of sale deed, they have gone for a unilateral execution of a rectification deed without taking my consent, and there is no pleading to the effect that there is fraud and there is no mutual consent, and it was done after 14 years. So court has held that it is barred by limitation, and it is so in view of the aforesaid provision of law under section 23 is relevant. In view of the aforesaid position of law as decided by the Honorable Division Bench of High Court, I hold that the deed of rectification or the deed of correction executed by the defendant has no legal sanctity, and the plaintiff is not bound by such unilateral deed of rectification or rectification. So the prayer for cancellation of such document made by the plaintiff is bound to be allowed by the court. So issue number 3 and 4 are answered in favor of the plaintiff. That is paragraph number 23 and 24 of the trial court judgment. Page 23 and 24, paragraph number 15, last 12 lines.
Yes.
So looking to such clear right, title, interest and possession of the purchased land having area of 270 decibel, it is to be accepted by the court that the plaintiff is entitled for a decree of permanent injunction against the whole world, including the defendant. So issue number 5 is answered accordingly in favor of the plaintiff. The plaintiff is not entitled to any other relief beyond the prayer. So he has not pleaded in the plaint that there is fraud, that there is any mistake committed. So why this rectification after 14 years? That is why the court has disallowed their prayer and allowed my prayer for declaration of right title and granted permanent injunction in against them. Now coming to the decisions of this honorable court has held in two 2001 volume 2 OLR 514 that it is well settled that a right accrued by means of registered document cannot be taken away by a deed of cancellation. Thus, the deed of cancellation has no legal basis and cannot take away the admissions made by the respondents in the agreement. He has executed sale deed in 1984. Both parties signed that document. There is a description of boundary in that sale deed, and after 14 years, how can he go for a deed of cancellation or rectification by showing a different boundary and different identity of the suit land? So court has held that it is barred by limitation, and one that sale deed cannot be set aside by.
That's all.
Yes.
I'm
closing
it then. I'll try my best to give a judgment before vacation.
It is also.
No, it has to be. Otherwise, my vacation will be spoiled. Both are one your suit, one his suit. All right. Hearing concluded, judgment is out. Huh? Item 1 so item number 1. I think Mr. Mishra, you had completed. He had granted him only 5 minutes to reply.
Schedule map.
Yes.
Map which I
place only judgment, few judgment and
extensively place କରିଛନ୍ତି ଆଉ ଯାହା note ଦେଇଦିଅ
note ବି prepare କରିଦେଇଛି
note ଦେଇଦିଅ note ଦେଇଦିଅ no where is that map?
Yes
sir ଗୋଟେ ଜିନିଷ କିନ୍ତୁ sorry ସେଥିରେ ଗୋଟେ ଯୋଉ କହୁଛନ୍ତି remand litigation started since 1988 2000
I got a point. I'm copy ଦେଇଛନ୍ତି
yes sir copy ଟା WhatsApp number ଟା ପଠେଇ ଦେବେ
copy ଟା ଦଉନା
sir actually sir this is a map which my learned senior was also showing the other day. This is from the evidence. This is undisputed, admitted jota facts both parties. Sir, map ta karichi sir.
So which is the disputed land? Jota pink ro
Sir, I'll just place it, my lord. I have it with me. Say pink sir ta hochi seta hochi ghoroi rasta ame kohuchu. That Sanjukta Swami plaintiff is the plot which is set, which is after the compromise.
He is the plaintiff.
I'm the plaintiff.
You are the plaintiff.
He is the defendant.
K. Manjuri Ram.
Tankara again.
से B scheduled land टा claim କରୁଛନ୍ତି A scheduled land ସହିତ କିଛି ସମ୍ପର୍କ ନାହିଁ. That has been settled in 1960. That suit number 160 of 94.
Admitted, sir.
No, for recollection of the memory, I am placing. They are claiming B scheduled land where there is no road. They are claiming easemental right of grant. It should be within the framework of the grant. It is a contract. What is there in the contract, that is should be guiding factor according to Supreme Court judgment. That Exhibit 3 is the contract they are showing. Exhibit 3 is the agreement. That was never proved. Exhibit 3 says where pani line and electricity line has been taking it to be true. If that has been true, then that is the line, electricity line and pani line is taken in western side of the road, where there is public road, not in B scheduled land.
Totally map ta bujhe diyo apne.
No, se jo map ta aji se douchoti.
Sire bujhai do.
Mu au thare clarification bujhe koruchu.
Sir, admitted bro clarification.
No, mislead kala asudha hejibo na jinso ta.
Yes.
Mislead jodi kariyo kahiyo sir jodi we are not for that. The mislead kahi kariyo court ko.
Na court apno court.
Sir, mane I respect you so much, sir.
No, settle B scheduled land ro konosi noksha nahi. ଆପଣଙ୍କର
ନକ୍ସା ନାହିଁ, ଆପଣଙ୍କ ସିଭିଲ କୋର୍ଟ କମିଶନର ନକ୍ସାଟାକୁ ମୁଁ କରିଛି
ନକ୍ସାଟା ବି ଲାଷ୍ଟ ଟାଇମ ଦେଖେଇଥିଲି.
Sir, let him first place it. Yes.
Lord, if your lordship kindly sees plot 426 personal 426 jota, that is undisputedly settled in my favor in a compromise faisla nama that was made rule of the court. Sir, जो 426 plot term sir देखो जी, that is the जो K Manjari Rana, Judhisthar Bassa, এটা entire plot टा हो जी 426. That was originally defendant number 1's property. जो all the faisla namas which have been made rule of the court in separate awards, all these plots were settled in name of the respective persons who were in possession. He relinquished his vendor, her vendor. Sir, say जो if your lordship kindly sees to the west of 426 where I am in possession.
Yes.
They are referring to that road. That is lane number 1.
Yes.
The entire dispute is how do I get to the government road, which is south to my property. Now, what my case is that pink portion, mark sir, for your lordship brevity, I was allowed to use that portion of the land to reach the L2. So the reason being, L1 is a 6 feet road. It's a pedestrian road. The road which is on the other side, the L2, that is a wider road. So for
has
me,
has it come in the evidence?
Yes.
This width?
Yes. That is admitted, my lord. That the civil court commissioner's report also says.
Okay.
Now, what he says is that there is this L1, the lane 1 is being used by me. I am not using this particular land which was given to me. That is where the reliance on that rule of the court schedule map is taken into consideration by the learned trial court. But suppose I file a sale deed. In that sale deed, there is a certain boundary description. That boundary description, so far as the other tenants are concerned, that may not be subject matter of dispute. But that sale deed boundary is accepted. So that is what the learned trial court held, that even if the Schedule A property, which is marked in fluorescence, that was subject matter of the Faisla Nama. That is admitted. Schedule B property is the pink property, pink marked. That property was never subject matter of the Faisla Nama. But however, this map came through in the schedule to the rule of the court. That he is bound by, because he has his vendor, she is not in the picture. Her vendor has not challenged it.
Vendor is Judhisthar Basa.
Ajay
Sahu.
DW3, Ajay Sahu. I'm grateful. So he has not challenged that schedule map. Now she cannot come forward and say that schedule map is not correct, it is not binding, the dispute was not between the parties. That is an admission by the vendor which she is bound by.
Okay, okay.
So that is one part. Second is, they say that it was never a rasta. It is not a rasta. It is portion of the property belonging to D2 that was allowed to be used as a rasta. It's a fine distinction, my lord. It was never a rasta. Now, he has led certain evidence to show that I have been throwing foul water. My lord, these things happen between boundary tenants. My lords, your lordship knows they are very vicious in terms of maintaining inimical relationship for decades altogether. So, releasing foul water is an instance in last 15 years which cannot be taken out in singular and said that this is not being used as a rasta. And my lord, this plot 426, he says that there is no house over it. He was not residing it. How? Because this conversion of the land schedule was made in the year 2011. So prior to that, because the plaintiff was in possession over the land, there was a Faisalanama in the year 1994. The conversion may be post facto in the year 2011, probably when they approached the municipality or the Gram Panchayat for a building plan and the approval, where the regularization of the building was made. But they are admittedly in possession over this fluorescent land since long. Well, that is the only clarification.
Yes. This was helpful actually, because to know.
Yes.
Anyway, Mr. Mishra, only 1 minute reply.
It is their evidence that they are not using B scheduled land. PW1 is the plaintiff, PW2 is the husband. Husband is also saying that through the four suits, no right of way was given. We are using the land which was in the western side of the A scheduled land. Western side of the land is the public road. B scheduled land is not a road. I am placing that particular evidences again.
Yeah, I have evidence.
That exhibit 3 is never proved. And the contract says the terms of, they are bound by the terms of the contract.
Yes. That you already have taken note of. These arguments have already been made.
And that
anything do you have to say with regard to this map?
That map I am placing the, this is this map given by the commission report.
I've seen it. Last time also you had it, Ashwin.
Yes. That in B scheduled land there is no road. At the extreme end, there is no road.
So, statement I suit a file koriche.
ଆପଣ ସୁଟ୍ ଫାଇଲ କରି ଆମ ଜାଗାରେ ନେଇଯିବେ କେମିତି ଗ୍ରାଣ୍ଟ ଟା ଯୋଉଠି ହବ have a glance to the Supreme Court judgments.
No, your judgment you give through that. I have heard you extensively on that day, both of you.
But there's 2 dates. This is the 3rd date.
So that is what I'm closing it.
One paragraph I am placing.
No, I am doctor. Tiffany, within a week.
Within a week, but
citation.
You have already filed.
Other citation much. After citation. Yes.
Item number 6.
6, 7, 8, 9.
I do that.
Item 6 টা দিয়ে ডিসকাশন করে আসি ମୁଁ କହିଛି ମିଷ୍ଟର ମହାନ୍ତିକି ପାଷ୍ଟର କହିଛି ସେ ମୋର ମାନେ ଆକ୍ଟିଭ କରିଛି ତାପରେ କ୍ଲାଏଣ୍ଟ ସାଙ୍ଗେ ଟିକେ କଣ୍ଟାକ୍ଟ ହେଇଛି ଭ୍ୟାକେସନ ପରେ ଏନି ଡେଟ୍ ଆସିବ
It was
ନା ପାର୍ଟ ଆଡ୍ ହେଇନି
no, not part add. On the last occasion also it was added on your
ମୁଁ ସେ ଫୋନ ନାହିଁ ମୁଁ ଚିଠିଟା ଦେଇଛି ଆଉ ଗୋଟେ ରେଷ୍ଟ୍ରି ଚିଠି ଦେଇଦେବି ନହେଲେ କରିଦେବି ମୋ ପାଖରେ ସବୁ କାଗଜ ବି ନାହିଁ
as requested by Sri Maheshwar Mahathir, learned counsel for the respondents, list this matter. Vacation for a date. We commencing 15th July.
Item number 7.
7 is this is a password लिखा है ना password लिखा है ऊपर वाले ये मनोइच्छा करछन ते को Yes, what is this matter?
Yes, I'm prepared to soft mode.
There are 2 appeals.
There are 2 appeals. I will be placing the facts. It will be clear. There is a small genealogy also phase 2. I have quoted everything in detail, but very shortly. And that placing the from prior one.
Hey, Mr. Mahanti, ଆପଣ ଯାଉନାହାନ୍ତି ବୋଲି ଆର୍ଜନ ନେଇଗଲେଣି ଆପଣ କାହିଁ ବସିଛନ୍ତି ଆପଣ ମୋ ମାଇଣ୍ଡ ସିଆଡେ ପଳଉଛି ଆପଣଙ୍କ ଭଳିଆ ମୁଁ ଏତେ ସିଭିଲ ଏକ୍ସପର୍ଟ ନୁହେଁ ଆଜ୍ଞା ନା ଆପଣ ବସନ୍ତୁ କଥା ତ ଯେ ମତେ ନ ଶୁଭିଲା ଭଳିଆ କଥା ତାହେଲେ ମୋର କିଛି କହିବାର ନାହିଁ ମୋ ମାଇଣ୍ଡ ସିଆଡେ ପଳଉଛି ଆଉ ମୁଁ ଏ ମହାନ୍ତିକୁ ଶୁଣିବି ନା ସେ ମହାନ୍ତିକୁ ଶୁଣିବି ସେୟା ଭାବୁଛି yes this is a genealogy no Mr. Mahanti why are you leaving ବସନ୍ତୁ ଆପଣ you please ସେ ନିଜେ କହିଲେ ଆଉ yes
RSA 383 of 19 is being heard along with
so this genealogy will be common for both the cases
yes it is only out of a counterclaim the second proceeding is arising as both the appeals arise out of a common judgment part in a lower appellate court dated so and so
you are reading from
para 1 I am placing
it's a
sequence para 1 from the first page
okay ठीक है
Khordha Bhubaneswar passed in 2 appeals, RFA number 59 of 2015 and RFA number 60 of 2015, dismissing both the appeals. 2 appeals before the lower appellate court arises out of one judgment dated so and so of the court of the learned first additional civil judge Senior Division Bhubaneswar passed in TS number so and so, dismissing the suit of the plaintiff and declaring the counterclaim filed by the defendant number 13.
Who are you?
I am the plaintiff, lost in everyone. The suit is one for partition filed by the present appellant as the plaintiffs. The counterclaim was lodged by the defendant number 13 for declaration of right title interest over Schedule C property of the plaintiff, for recovery possession of the same from the plaintiff and for purchase of and a grocery shop. The important factor is the purchase is being made in the name of Dvijaras. That is for consideration. Parshuram again purchased another one acre land in the name of Dvijaras again. In the same moja out of joint family income as indicated above. Then 1950 to 53, Bhaskar, the original plaintiff, returned to his village from Kolkata where he was in a private service to look after the landed properties. By then, Dvijaraj was working at Cuttack Collectorate and Ganeshwar was working as the revenue inspector. At this point of time, Dvijaraj suggested to acquire a piece of land at Cuttack for the joint family. Ganeshwar and Bhaskar agreed to the proposal and also contributed money for the joint family nucleus to Dvijaraj, who was entrusted with the work of acquisition of the property. Then 1956, Dvijaraj, however, obtained a sale deed in the name of one Pradeep Kumar Rautray, minor of 2 years, son of Vaidyanath Rautray, acting himself as the guardian piece of the minor. This document is Exhibit 14. This was not within knowledge of the plaintiff. A building was also constructed over the purchased land with the joint family funds, and the joint family remained in possession of the enjoyment of the sale. Then 29/11/1963, while the matter stood as above, Dvijaraj got a deed of relinquishment from the said minor executed in favor of his own wife Radhamani. Radhamani kindly have a glance. She has been added as defendant number 1 in this suit, Exhibit 15. All these transactions were made surreptitiously or were also not within the knowledge of the plaintiff. Then 13/5/1964, another property described under Schedule C of the plaintiff was acquired in the name of Dvijaraj under registered lease deed number sponsor out of the joint family funds. Then 29/1981, while the matter stood as above, taking advantage of the fact that the property under Exhibit 15 of the year 1963, which was in the name of the minor, acquired in the name of the minor and transferred in his wife's favor, was acquired in the name of the Radhamani, the defendant number 1, the latter again executed a nominal deed of gift in favor of her sister Brajavala and her 2 sons, Biswajit and Satyajit, who were defendant numbers 5 to 7 in this suit. With the aforesaid sequence of events, the original plaintiff pleaded that the entire joint family relied upon Dvijavar for acquisition and management of the document of the property, which were kept with him. At one point of time after his retirement from the government service, Dvijavar also sold substantial extent of ancestral properties for his medical expenses. It was therefore pleaded that the properties described above, covered under Schedules B and C of the plaintiff, though acquired in the name of Dvijavar or acquired by him in the name of others as indicated above, are the same as joint family properties of the family in which the original plaintiff has 1/3 share. After the death of Dvijavar, his defendant number one and other defendants are there. Substantially, other defendants accepted the plea of defendant number one. Defendant number one substantially contested. The defendant number one appealed and contested the suit by filing written statement while refuting the plaintiff's assertion of the joint family character of the suit schedule B and C properties. It was pleaded by her that three brothers, that is Ganeshwar, Bhaskar and Dvijavar, were separated in the year 1947. It was pleaded by her that schedule B properties are her exclusive properties purchased out of her Stridhan. Similarly, schedule C properties are the exclusive properties of Dvijavar, after whose death she is the exclusive owner of the property as his only legal heir. It was also disclosed that the defendant number one has sold schedule C property during pendency of the suit in favor of defendant number 13. This is a lis pendens transfer. Now, defendant number 13 has filed the counterclaim and delivered possession. With the above pleadings, defendant number one sought for dismissal of the suit. The other defendant numbers 4A, then defendant numbers 5, 6, 7, and defendant number 11, and defendant number 14 and 15 filed separate written statements, but they almost supported the pleadings of defendant number 1. The case of the defendant number 13, he is the purchaser, lis pendens purchaser. The defendant number 13 is a lis pendens purchaser from the defendant number 1, filed separate written statement supporting the claim of the defendant number 1. Along with the written statement, this defendant number 13 lodged a counterclaim in respect of the schedule C property of the plaintiff. It was pleaded by this defendant number 1 that he purchased the property in question by RST number so dated 20/12/1999 for appropriate consideration, specifically pleading that possession was delivered in his favor. Nevertheless, this defendant, while making the counterclaim, pleaded that he approached the original plaintiff and his sons time and again to vacate the house, but with some plea or other, they were delaying and dragging the matter and ultimately refused to vacate the house. Therefore, he filed the written statement with counterclaim for declaration of title, eviction, and permanent injunction against the plaintiff. On the basis of the pleadings of the parties, the learned trial court framed as many as 15 issues for decision of the suit. Both the parties laid their respective evidences, both oral and documentary. Then findings, learned trial court took up issue number 5 to substantially answer the question as to whether the schedule B and C, should B and C schedule property are the joint family property of the plaintiff and the defendant numbers 1, 2, 1, 3, 2, 3, and 4, or self-acquired property of late Dvijavar's family. Among other, the vital document on which the plaintiffs placed their reliance is Exhibit 18. I will come to it later. This Exhibit 18 is the certified copy of the proceeding in OLR case number so in which all the three brothers, that is Ganeshwar, Bhaskar, and Dvijavar, were parties to show the jointness of the suit property, including the properties covered under schedules B and C. Apart from the above, two more documents, that is Exhibit B and N, filed by the contesting defendants, were taken aid of while deciding this issue. The learned trial court, after taking into account the above three documents, came to a conclusion that first, there was severance of joint status taken place in the family long back. After taking into account, there is a missing. The oral evidence of the parties, the learned trial court further came to a conclusion that Dvijaraj, who was serving at Cuttack, has acquired the property from his independent income, and the plaintiffs have failed to discharge the burden that the schedule B property has been acquired from the joint family funds. It's para 24, it is the finding. Similarly, also the property under schedule C is concerned, the learned trial court came to a conclusion that the properties under schedule C has been acquired from the joint family funds. Property has not been acquired from the joint family funds, but the same has been acquired by Dvijaraj from his independent income, and therefore it is his self-acquired property. Thus, in this issue number 5,
B and C are his self-acquired property.
all the properties were held to be. In this issue number 5, the learned trial court ultimately came to a conclusion that the properties covered under schedules B and C are not joint family property, but the self-acquired properties of Dvijaraj. Therefore, on the basis of the findings tendered under issue number 5, the findings under issue numbers 6, 11, 13 went against the plaintiff. Under issue number 7, 9, and 12, the learned trial court decided the question as to whether the transfer made by the defendant number 1 in favor of defendant number 13 by registered cell deed dated so-and-so Exhibit K. This is the lis pendens cell deed. During subsistence of the order of status quo is valid in the eye of law or not. Ultimately, the learned trial court also came to a conclusion that the purchase made by defendant number 13 is valid in the eye of law.
Yes.
Under issue numbers 8, 10, and 14, the learned trial court decided the question as to whether the defendant number 13 is entitled to reliefs claimed under the counterclaim. It was ultimately held that the said defendant number 13, being the lawful owner of the property purchased by him having right title interest, he is entitled to relief to get vacant possession and permanent injunction against the plaintiffs. The other issues being formal in nature, the same were answered against the plaintiff and the suit was dismissed. Then the two appeals were preferred and against judgment, second appeal has been filed. Now, I have quoted my 2-3 grounds of my challenge. At the first instance, it may be submitted in this connection that in absence of any written document of partition in the family, both the courts will have completely misread the documents under Exhibit B and Exhibit N to come to a conclusion that there was severance of status in the family. Exhibit B is a proceeding.
Mr. Mahathi, just a moment. Today also in the morning on the same point,
I was present.
oh, you were there.
Severance
Is it always necessary that there has to be a document?
No, I don't say that. But severance of status
Has
doesn't
to be
mean.
proved through oral evidence, it can be proved through collateral evidence also, it can be proved.
Yes.
Whether it has been proved in this case or not is a different matter.
No, not
I'm
in
just
this
asking on this principle.
Severance of status doesn't mean partition by meets and bounds.
I have admitted it on that ground
Yes,
today.
exactly,
You have seen.
exactly.
Whether severance of status automatically leads to partition by meets and bounds.
Yes.
That is the question I framed today.
Yes. Here, merely because two documents are there, and only coming to a conclusion that there is a severance of status, Learned Trial Court comes down to a conclusion that there is a partition by meets and bounds.
Okay, okay. Then Exhibit B.
Exhibit B is a proceeding under the Conciliation Act in which parties sought for partition of certain properties.
Okay.
Kindly mark the importance.
Yes.
In a proceeding, the parties seeking for partition.
Obviously showing jointness.
Obviously showing jointness. Learned Trial Court comes to a conclusion that because the parties are seeking partition, there is a severance of status.
Other way around.
If there is even admitting that there is a severance of status, if the parties are coming forward with a proceeding to partition the property, can it be concluded that property shall be partitioned? The answer is obviously no. But here the answer has been given against the plaintiff. Then Exhibit N is a registered sale deed under which Dvijara has sold his share in certain properties of the family. There is no bar of selling the shares. Even
to the extent of his share, it will be valid only to the extent
without
of share.
taking into account the other documents exhibited, that is documents exhibited, that is the record of rights under Exhibits 1 to 13, which still remains joint, Exhibit 21 to 27, which include holding tax, receipts, thousand rent receipts, ration cards, and voter identity cards, and other oral evidences available on record, which categorically prove the joint character of the suit properties, and the oral evidence on record, the finding of both the courts below have turned erroneous in the eye of law. At pausing at this moment, kindly have a glance at the exhibited list of the Learned Trial Court.
ଇଏଟା ତାହେଲେ ଏଇ ଯୋଉ LCR ଟା ଅଛି ନା ଆମର ଏଠି LCR ଅଛି ଆର ନାଇଁ ଏଇଟା ଆଇଟମ କେତେ
Exhibited
ଏଇଟା ଅଛି LCR ଅଛି
exhibit list.
List of documents ଯଦି ଅଛି ମତେ ଦେଇଦିଅ ଏଥିରୁ ସେ ତ ଜାଣିନାହାନ୍ତି ସେମାନେ ତେଣୁ ଯାହା କରିଥିବେ ଆଉ ଅଛି ହଉ ହଉ ସିଭିଲ ରେକର୍ଡ ଗୁଡା ସେମିତି ଆଉ କିଏ କଣ କରିବ the scanning staff, they do not know how to, what is what. Otherwise, it would have been easy to look into the, the time petition, Hajira, objection, is which is scanning. Hajira, substitution petition, written notes, Vakalatnama. Petition filed, petition, objection, Vakalatnama, objection, 26-1. There is no list of documents what watch the no the file Which document do you want me to see?
There are about 17 or sorry, 13 numbers of record of rights from exhibit 1 to exhibit.
Let us assume that those they are joint.
Even in the name of Parsuram.
Parsuram is the original, the common ancestor.
Common ancestor.
Okay. So that is what you want me to see.
Yes.
Well, let
What
us
I can
accept it.
submit is, if the documents remain joint, had it been there is a complete partition.
That's what. It is integrity of index, deposition, list of exhibits with exhibit type.
Deposition date was.
Deposition दरकार नहीं. Exhibit list होते तार तौर को थी वो. ये जो है. हाँ. Exhibit 4. Yes. You have many documents have been marked. Up to exhibit 33. 33 series. Exhibit 33 series. Some of the series collective documents are 104, 51, 55. Same document file. So these are all, I see that certified copies of ROR.
ROR.
Exhibit 1
to 13 for exhibit 21 onwards.
21 is
21
holding tax receipts.
Tax receipts.
Then ration card, voter ID cards, electricity bill, PhD water bill.
Once there is a partition, if this property belong to this Dvijaraj or his family separately, can the plaintiff get these documents to jointly parent and jointly enjoy the property with these type of documents?
Okay.
And while examining exhibit B and N, none of these documents have been considered either by the trial court or by the appellate court.
So why should I open it? I have taken it.
Just document list of documents judgment.
Flag marta नहीं पुन रखी report. तो देखिए flag मारो हाँ. ये flag मार के रखें सर.
I'm coming back to page 10, to next ground.
Yes.
The manner in which the property under Schedule B was acquired by Dvijavar in the name of minor child, acting as his uncle guardian, and thereafter executing a deed of relinquishment in favor of his own wife, sufficiently smells of malafide on the part has taken. Both the courts will come to a conclusion that the person to challenge is the minor. Here they have not come forward. That is why they have discarded the plea. And
because it is voidable. It is voidable.
Yes. So I am not placing that also.
No, I just wanted to know.
Yes, that ground was taken. Depending on one in acquiring the property in Schedule B of the plan. In view of the above, whether the learned courts below are correct in not drawing proper inference in the said document, probably that is one ground. Then most important aspect of the matter is that learned lower appellate court suffers from gross error of record while considering exhibit 18. Exhibit 18 by coming to a conclusion that even though the properties under Schedule B and C of the suit are available at serial number 38 and 39 of the exhibit 18.
Exhibit 18 টা কোন?
সেটা ঠিক আছে দেখাচ্ছি।
Exhibit 18 টা বার করো।
সেটা not দেখলে কি লাগবে? Separately notice.
ମୁଁ ଯୋଉଟା ଫୋଲ୍ଡ କରିଥିଲି ସେଟା ଲିଷ୍ଟଟା ସେ ଅନୁସାରେ exhibit 18 ଟା ବାର କରିବ।
ପେଜଟା exhibit 18 OLR proceeding ର certified copy.
No. Unlike the trial court, actually they are not so acquainted again. And this being a miscellaneous court, so naturally. This is the order sheet.
order sheet ता परकु भी अछि तार petition and ଗୋଟେ memo अछि. This is an order passed in the Euler proceeding where a person named Pranakrishna Parida से जो certified copy order sheet page का running page 5 को टिके आसी kind.
Running page 5.
The last portion of the order. A Euler case.
Euler case number 1354 of 1976.
आगे.
Last portion is अपन को गोचरार्थ है.
नहीं से जो English रो concluding paragraph after hearing this I believe.
I believe that since Sri Pranakrishna
Parida is trying to purchase the suit land and one of the joint owners is not willing to sell the land, he has instituted this Euler case. Pranakrishna Parida filed this case for declaring him as a tenant under all the brothers as a bhag tenant. All the brothers were made parties to this case also, where all the brothers have admitted that the properties are joint. And it is he is not a bhag tenant, the land. Moreover, one of the joint owners of the suit land is disabled person. Then here at least the claim was made that the properties are joint properties and which was admitted also. Kindly have a glance at the next. There is a revenue inspector's report. Next page. This report says that properties are joint. ଗୋଟେ ୱାର୍ଡ ଅଛି ଏକ ଇଜମାଲି ହୋଇଥିବାରୁ ଅନ୍ୟାନ୍ୟ ଅଂଶୀଦାର ମାନେ ଦରଖାସ୍ତକାରୀଙ୍କୁ ଏହା କବଲା କରିପାରୁ ନାହାନ୍ତି. Page 2 revenue inspector report, page 2 para 2, 8th line from the top.
सरजमीन तदंत कर देखिली स्थानीय साक्षी मानकटो जहाँ बुझिली सेथु जणा जाए जे दरखास्तकारी उक्त विवादीय जमी को वर्तमान भाग चाष करि नांती
जमी को केबे हेले भागरे चाष करनते केवल उक्त प्रति घर बाड़ी करिया उद्देश्य किणीमा निमंते समस्त जसंस टका दरखास्तकारी प्राणकृष्ण परिडा पिता बळानंद परिडा संस जमी मालिक गणेश्वर स्वाई पिता परशु स्वाई सिंगरा स्वाई को देथिले किंतु एही एक इजिमाली होइथिबारु अन्य अंशदार माने दरखास्तकारी को यह कबला करि न परिबारु सॉरी चार बच्चे सॉरी
इजमाली होइथिबारु तेनु अन्य
होइथिबारु अन्य अंशदार माने दरखास्तकारी को यह कबला करि न परिबारु दरखास्तकारी उक्त जमीरे कोनोस मध्ये मालिकाना हासिल करिया निमंते संस माय पॉइंट इज the property was claimed to be a joint property also of the entire family. This is not all. Next, kindly have a glance. There is a memo after this RIS report.
निवेद्य है कि?
No, sir, it is in English to the revenue inspector. कुजंग sorry, निवेद्य है कोडिया. निवेद्य है कि ऊपर लिखित मुकदमा संपृक्त जमी आंभर पिता स्वर्गत परशुराम स्वाईଙ୍କ नामରେ दरज अछि. तांको मृत्यु पर आंभे प्रतिवादी माने 91 भाषा करी उक्त संपत्तिर समस्त समान सत्ताधिकार थाई दखल करि आसियोछु. एथि सहित आंभ 91 परिवार समस्त संपत्ति 91 परिवार समस्त संपत्ति घर बाड़ी और चाष जमीर तालिका एथि सहित संलग्न कराला. काइंडली सी द सिग्नेचर. भास्कर स्वाई द प्लेंटिफ, द्विजबर स्वाई द डिफेंड नंबर 1, द हस्बैंड ऑफ डिफेंड नंबर 1. They themselves filed this petition saying that the properties are joint properties. Now the list of properties is there. Next page. And coming to the list of properties, after what observation has been made by the lower appellate court. This is substantially my ground of challenge in item number C. Kindly have a glance at paragraph number 34 of the appellate court judgment. Page 32, paragraph 34.
Para 34 and 35 takes care of exhibit 18, my lord, which my lord in senior is related.
Yes, that's exactly I'm placing. Para 34 and 35.
Just for a moment, other respondents are not appearing.
No.
Notice has been served.
Interestingly, the appellate court has observed that despite Ganeshwar being made a party, but none of the legal...
No, but before this court?
Not even before this court.
No, was notice?
Not before the trial court.
Was notice served?
Yes, yes, before the trial court, notice was served. Nobody came forth from the side of Ganeshwar, and even in the appellate stage, and also over here, my lord.
Obviously, you have a limited role to play, being the list pendants purchaser.
I am appearing for the list pendants purchaser and 567 also, my lord.
567, who there?
The owner of Schedule B property, which is situated at Cuttack. And
Schedule B is Dvijaraj.
no, my lord.
No,
It has been pulled away.
The sister of different number one is two children.
In fact, like I am there for the purchasers, my lord.
Independent purchasers.
One is through a gift deed, the other one is through a sale deed, my lord.
Okay. 35.
34. Page
34, yes. The plaintiffs use exhibit 18.
Plaintiffs use exhibit 18, certified copy of the order sheet and inquiry report in OLR case number 1354 of 1976 as a trump card to bring home their contention that Schedule B and C properties are joint properties. The plaintiffs claim that in the OLR proceeding, Dvijaraj described Schedule B and C properties as the joint property. In this regard, the plaintiffs have drawn attention of the court to the certified copy of the joint application of the Dvijaraj with Bhaskar sign, dated so and the list of joint properties annexed to the petition. It is argued by the plaintiffs that in the serial number 38 and 39 of the list, Schedule B and C properties have been noted. So the list being the joint property, it is to be held that Schedule B and C properties are also joint properties. However, on perusal of the joint petition reveals that Bhaskar and Dvijaraj have noted in the petition about the property of their father Parsuram Swami. In the petition, there is no reference about subsequently acquired properties, that is Schedule B and C. Schedule B and C. Further, a perusal of the list in two sheets, supposedly annexed to the above noted joint petition, reveals that on the first sheet, some properties have been mentioned against serial numbers 1 to 19. Serial number 19. Kindly have a glance at that. See. Left side serial number 1 to 19. 19. And on the second sheet, Schedule and B properties have been mentioned. Pratham ru Schedule B, C, B, C nahi. But subsequently on the second sheet, Schedule and B properties are mentioned. Kindly have a glance also at the Schedule B and the next page, item 38 and 39.
Yes.
These are properties of Schedule suit properties. Mentioned. But very strangely, serial numbers 20 to 37 of the list are missing. The comes at 22 on the very first page, say 20 to 20 37 the second column itself. Second column, it is continuing.
He has missed it.
Continuous.
He has misread it.
Misread the entire finding on that. Kindly so the list is not complete and the plaintiff do not explain missing part of the list. That is the properties noted against serial number 22 to 37.
It is a perverse finding.
This mistake this makes the list doubtful. Further, on the list at places, there are overwritings and use of pen in different keys. Those writings are formal, then there is no dispute to that list properties that list.
I think the court is not entitled to pass any opinion on this.
After
I think it is part of the OLR record.
Yes, this is a record. 35 copy I have produced.
Anyway,
writings have also been scored out. The total acreage has also been scored out and written at 6 so and so. There is no initial below the overwriting using blank so and so. So the list appears to be suspicious and it seems to have been procured for the purpose of this case. This is of the year 2000, when it was made, 76. Therefore, cannot be relied upon. Further, the very credibility of the OLR proceeding stands demolished by the evidence of PW1, who had stated in para 43 of her deposition that Pranakrishna Parida was not their Bhag tenant and he has filed a fake OLR case claiming to be Bhag tenant. This is not a mistake at least, because their claim is that a wrong person has come forward. So this is not false, but it is being quoted. In the same para, PW1 has admitted the suggestion that to save Bhaskar and Ganeshwar, Dvijaraj has signed on the objection on the OLR case. This testimony of PW1 lends credence to the contention of the defendants that Dvijaraj had signed in the objection petition to save ancestral lands being given to the Pranakrishna Parida by OLR authority. He himself saying that his ancestral property. What is the wrong in the statements and what is the in view of the above reasons, thus it cannot be held that on the basis of Exhibit 18, Dvijaraj admitted Schedule B and C properties and unfilled properties of OLR case. This finding itself on this document at least, the finding is erroneous and completely vitiated, and there is, if it is accepted, the consequences are not being considered by the lower appellate court. Therefore, the ultimate finding, even other findings are there. I don't dispute properties are partition, etc., etc., etc. if the vital document is being ignored in view of an erroneous finding, this judgment is erroneous. And that is the ultimate.
Well, that is it.
That's all.
As I said right from the beginning, not to stop you from arguing, but you have a limited role to play.
But
another.
You have to step into the shoes of the your vendor.
Yes, my lord. And
Yes, Mr. Mahathi, anything else you wanted to say?
No, I will recite the judgments on the question as to whether the list, because different number 13 is the list pendants purchaser. That too during substitution of the status quo. What is the effect of such a document? I have judgment.
No, but even assuming, because much water has flown down the bridge ever since he has purchased.
Yes.
So obviously he may not be ousted. His what would be his role now? What would be his entitlement?
No, if the
even accepting that exhibit that schedule B and C property are joint family properties.
Joint family properties.
So his
partition, if it is partition, 1/3. Plaintiff share is 1/3.
Okay.
The only substantial question of law which has been framed by this honorable court is that whether the court below have committed grave error in not considering exhibit 18 in its proper perspective, and by misconstruing the same have arrived at.
Do you need to see this?
Yes,
you want me to see this?
Yes, ma'am.
I will remember. Good.
In misconstruing the same have arrived at the conclusion that the same has no such impact in rendering the finding with regard to the nature of property under Schedule B and Schedule C as claimed by the plaintiff to be the joint family property. Now, my lord, the plaintiff claims that there is a joint family, there's a joint family fund, there's a nucleus within the fund, and from the nucleus, the property B and C have been acquired. My lord, both the courts below have concurrently held that the plaintiff has singularly failed to establish the fact that there was a nucleus within the joint family fund and the property B and C were acquired. My lord, now coming to exhibit 18, my lord, once again, I would like to place paragraph 34 and 35. My lord, paragraph 34, I'll just place it, my lord. The plaintiffs use exhibit 18 certified copy of the order sheet and inquiry report in OLR proceeding number 1354 of 1976 as a trump card to bring home the contention that Schedule B and C properties are joint properties. That the plaintiffs claim that the said OLR proceeding, Dvijiraj described Schedule B and C properties as joint properties. In this regard, the plaintiffs have drawn the attention of the court to the certified copy of the joint application of Dvijiraj with Bhaskar Swain dated 3/12/1976. My lord, in the OLR proceeding, it's only Dvijiraj with Bhaskar. They only participated in the proceeding. It's not all the three brothers. And a list of joint properties annexed to the petition. It is argued by the plaintiffs that in serial number 38 and 39 of the list, Schedule B and C properties have been noted. So the list being the joint property, it is to be held that Schedule B and C properties are also joint properties. However, on perusal of the joint petition reveals that Bhaskar and Dvijiraj have noted in the petition about the property of their father Parsuram Swain. In the petition, there is no reference about the subsequently acquired properties with Schedule B and Schedule C properties. Further perusal of the list in the two sheets, supposedly annexed to the above noted joint petition, reveals that the first sheet, some properties have been mentioned, again serial number 1 to serial number 19. And in the second sheet, schedule number B and C properties have been mentioned at serial number 38 to 39. But very strangely, serial number 20 to 37 of the list are missing. So the list is not complete and the plaintiffs do not explain the missing part of the list. That is the properties noted against serial number 20 to 37. This makes the list doubtful. Further on the list, at places there are overwritings, use of pen and different inks and writings have also been scored out. The total acreage has also been scored out and written at 6.98. There is no initial below the overwritings using blank ink and scoring out. So the list appears to be suspicious and it seems to have been procured for the purpose of this case, therefore cannot be relied upon. Further, the very credibility of the OLR proceeding stands demolished by the evidence of PW1, who has stated in para 43 of a deposition that Pranakrishna Parida was not their Bhag tenant and he has filed this fake ONR case claiming to be Bhakdev. And in the same paragraph, PW1 has admitted the suggestion that to save Bhaskar and Ganeshwar, Vijiraj had signed the objection of the OLR case. This testimony of PW1 leads credence to the contention of the defendants that Vijiraj had signed in the objection petition to save the ancestral properties being given to Pranakusha Parida by OLR authority. In view of the above reasons, thus it cannot be held that on the basis of Exhibit 18, Vijiraj admitted Schedule B and C properties to be the joint properties of OLR proceedings. But my respectful submission before your lordship is that Exhibit 18 is not the only evidence on the basis of which both the learned courts have come to a finding that B and C are not joint family property. Well, Exhibit 18, my lord, what from the reading it appears that your lordship has also seen the document. The learned court, the appellate court comes to a finding that serial number 1 to 19 has been given. But then thereafter, the properties, B and C has been mentioned as serial number 32 or 31.
38 and 39.
38 and 39, madam. So therefore, in between the properties are missing.
No, they're there.
Madam,
they are there. जो तुम बात कर देखे देवी ना
second column. Right. See, it will miss caption.
मिस करिए
Okay. Well, anyway, but I'll take instruction on this. But
you don't have to take instruction, and nothing remains. The only thing that I asked the question to, what will be your entitlement now? Supposing this court holds that it is joint family property.
But now
you are still entitled to, because you are the purchaser?
Yes, my lord.
And you say lease pendants. After the file suit was filed.
No. Even that, well, so far as lease pendant purchase thing is concerned, my lord, both the courts have come to a finding that even if the property, if the appellate court comes to a finding that cannot be said to be a lease pendant, I need to read out those particular paragraphs, my lord. May I read out, my lord?
Yeah, please. All right, we'll then take it up next week. You want to take some?
Yes, sir. I'd like to take instruction then.
All right. Third in part. This is matter next week. Next week we'll complete it. I didn't want to keep it. Then. All right.
Yes, sir.
You just dharkar au kon kare. I would roll. Item number 8. Item 8.
Your Lordship, my senior is on his legs if this matter can be taken next week.
2022 matter will take it up next. All right. After vacation for this. Let's just matter in the week commencing 15 July. You probably you have also missed that line because it is very clumsily prepared, that list.
Well, I'll take it.
Take instruction. And you also find out what would be your right.
Yes, sir.
Lease pendants purchaser or not lease pendants purchaser.
Yes.
Admittedly, you have to step into the shoes of your vendor,
yes,
which is defendant number 1.
Yes, sir.
Isn't it?
Yes, sir.
So you still have a right. It's not as if you don't have a right, even if it is held as joint family property. Okay.